The Senate Judiciary Committee, Policy Committee, will come to order. I'm going to kind of give you a little roadmap for what we're going to do this afternoon so everyone can understand how we're going to approach this. We're going to have Senator Dibble's Senate File 1641 on medical marijuana use authorization. We're going to give the proponents 30 minutes to make presentations. We will give the opponents 30 minutes to make a presentation. We're then going to take some testimony on the fiscal note. We are meeting as a policy committee only this afternoon. We are not meeting as the Finance Committee division. However, we're going to take our information relating to any fiscal impact at the committee hearing this afternoon and then anticipate that if the bill moves forward to full Finance Committee, then the full Finance Committee will be able to determine if they want to just deal with it as a full committee or if they wish to send it back down to us as a division. I'm anticipating perhaps we will not be meeting as a division on this separately. It'll just be full Finance. And then we have time after the formal presentations for discussion and amendments and questions and so on. And then we'll wrap up. So with that said, welcome everyone to the committee. Senator Dibble, Senate File 1641.
Great. Thank you, Mr. Chair. I appreciate your having this hearing. I appreciate the time and attention of your committee, particularly in light of the fact that this is a late bill and a pretty big bill. So appreciate the indulgence this late in the session. Of course, we're here at the invitation of other folks who are desirous of our moving ahead and having a full and fair and open debate on the merits and the policy around this proposal and this idea. Mr. Chair and members, Senate File 1641, by way of high-level summary overview, would allow a program by which individuals who suffer debilitating medical illnesses to have access to cannabis to help treat and alleviate some of the symptoms that they struggle with. Mr. Chair, I'll do a high-level overview, not a straight walkthrough of the bill, and then, if you like, I can focus in on the sections that I know as identified by your staff that are particularly relevant to the jurisdiction of this committee or not. We can get to that later, and we can go to testimony. Does that sound agreeable? Yeah, that's fine. And the time that you spend presenting the bill to us so we understand what's before us is not part of the 30 minutes, just so everyone understands that. Great. Thank you. So, Mr. Chair, like I said, this bill allows seriously ill patients whose doctors recommend medical cannabis to register to use and to safely access a very limited amount of it. And these are only for certain qualifying conditions as spelled out in the bill proposal, and you can find that in the definition section. The Health Department, the Commissioner of Health, may add conditions in the future, but undergoing a specific process of consultation and hearing. Folks can also petition to have conditions added, but again, it would have to go through a process of consultation and hearings and the like. Patients are limited to no more than 2.5 ounces at a time, significantly lower than many other states. Patients must have a Health Department issued photo ID card, which can be easily verified by police in the alternative treatment centers. Alternative treatment centers is the expression that we use for dispensaries. I'll add parenthetically that a patient can only obtain cannabis from one identified alternative treatment center. They can't just go to any. The certifying medical professionals are only doctors, medical doctors, and doctors of osteopathy, and they issue a written certification for their patients who have the qualifying conditions, and again, conditions and a procedure is set forth, making sure that that is a function of primary care and a function of a thorough analysis and examination, et cetera. Minors do have access, but only if they qualify with 2 of those written certifications, if their parent or guardian consents in writing, and the parent, of course, is in charge of the substance, the cannabis, et cetera. It does provide for modest anti-discrimination protections, because as we know, ADA does not apply to use of cannabis, preventing folks for discrimination in a number of endeavors, being fired, renting, et cetera. It provides for a defense for folks who are in possession. It prevents arrest and charging if folks have their card, and provides for a defense if folks, before their card has been issued, but they're agreeing to all the stipulations and the card is on the way. It provides for an affirmative defense. We'll get into that in a little bit, Mr. Chair. There will be only a maximum of 55 alternative treatment centers statewide, and that's based on the numbers based on a per county basis and driven by the population in a given county. The commissioner has sole discretion over the approval of the opening of an alternative treatment center for any reason, significant authority in writing rules over who can open one, what their business plan is, what their operating conditions are, et cetera, et cetera. That will be done through a competitive application process. And like I said, considering factors such as the character of the applicants, the business plan, security plans, and the proposed location. Cities, counties, other land use authorities can enact their own zoning regulations as well that are done so within reason. A patient can designate a caregiver to pick up their medicine for them and help them administer their medicine. That caregiver is subject to many of the same oversights and rules and regulations as the patients are themselves. There are a significant number of fees, and when we get to the fiscal discussion, we can discuss the fiscal implications, but the short version is that the fees that are assessed either to the alternative treatment centers or the safety compliance facilities, these are the labs that help the alternative treatment centers make sure that what they're selling is weighed properly, has certain measures in place, et cetera. They'll be charged significant fees, and additionally, patients will pay $100 per year, in some cases $25. So the fees are stipulated to support all the activities that are called for in the proposal. An advisory council is created to advise on rules, on the alternative treatment centers, possible improvements, all the aspects that go into implementing the provisions of the proposal, as well as there was an assessment or a study that was added at a previous committee, and this advisory council is charged with carrying out that assessment in consultation with stakeholders and members of the larger public. It imposes a significant number of safeguards. I spoke before of the safety compliance centers that would be required to provide laboratory testing and labeling, develop regulations. In the health department is required to develop regulations for these testing laboratories so that patients know what levels of cannabinoids are in their medicine and that they're pure, they're free of contaminants. The health department is also tasked with developing stringent rules for the alternative treatment centers, including governing, oversight, security, labeling, and packaging, containers that are child resistant, signs, advertising, like I said before, location issues, et cetera. The health department also will accept and investigate any complaints and perform inspections. Only alternative treatment centers can cultivate in cannabis, and they have to do so in an enclosed, locked location that is registered. All cannabis will be tracked, and getting back to the location issues, all of these centers must be at least 1,000 feet from schools. There are a significant number of limitations on the use of this medicine, such as driving in public, in places of employment, in rented living spaces, et cetera, in the presence of a minor. Anyone who's using cannabis for medical purposes is subject to all existing regulations around use of cannabis not for medical purposes. In addition, if they violate any of the restrictions and any of the conditions in the bill. They would lose their ability to access cannabis. If they divert cannabis for any reason, they face penalties of up to 2 years in prison and a fine of up to $3,000. So this is in addition to any existing legal liabilities that they face. Likewise, any dispensaries that break the law are subject to significant fines and consequences, and of course the inability to continue to work in this arena. Mr. Chair, I think the sections that are particularly, and Mr. Chair, I do have an amendment to offer as well that buttons up a few items that emerged from the last hearing, and then is also the product of some work that staff to this committee has done on data practices. So this is, Mr. Chair, is the A15 amendment. I can walk through that now. There are two different A15 amendments, I think. There's one not from me.
Yes, and one's yes.
So members, the amendment is being passed out.
Okay, Mr. Chair.
All right, go ahead, Senator Dibble.
So I'll just walk through the amendment quickly, if I may. So on line 1.2, that's just a correction to a reference. On line 1.3 of the amendment, then that goes to line 1.6. That's picking up some language that occurs later in the bill. It's putting it into the section of the bill that has to do with the requirements for the medical cannabis organizations, the alternative treatment centers, and the safety compliance centers, and how they treat information and data relating to the card holders. So it's just simply putting that in a more appropriate location. Then staff kind of did another run at Section 13, which is the section that has to do with data practices. And I think it conforms some of the language more in keeping with how we discuss data practices, and also developed some approaches and picked up on some issues that we hadn't yet picked up on. Maybe Ms. Pontius can help. Ms. Pontius wrote this amendment, and maybe she can help walk us through this section 13, line 1.8 through 1.32.
Ms. Pontius.
Yeah, Mr. Chairman, members, as Senator Dibble pointed out, basically this just rewrites Section 13, which currently says confidentiality, so it just is actually the data practices provisions. And it's just stylistic language changes. A couple things I would point out. There was language in the bill right now that referred to releasing the data as part of the annual report. But the report itself says that it can't include identifying information, so it raised some confusion as to whether somehow private data could be in the public report. So it just takes that clause out. And the report itself would not include data on individuals. And then also, if you look on line 1.27 of the amendment, and through 1.29, the two new clauses, those are ones that were suggested by the Information Policy Analysis Division, just as kind of common language that's used for data sharing, either for purposes of complying with data practices law or for audit purposes. So those are actually two new user clauses that are there.
Thank you, Ms. Pontius. And then, Mr. Chair, we add a member. This is a suggestion, a part of a suggestion that came from Senator Hall at the last meeting. So we add a member. So we have an odd number of members for the Medical Cannabis Advisory Committee. So you can find that on page 22. So the Medical Cannabis Advisory Council language starts on line 7 of page 22. We increased the members to 9, and the member whom we add would be you find on the flip side, starting on the top of the second page of the amendment, a chemist or other scientist with professional expertise in evaluating the properties and qualities of cannabis would be appointed by the Commissioner of Health. And then the rest of the language is just catching some errors and doing a little cleanup on the next page. And that's my amendment, Mr. Chair.
All right.
If anyone would like to offer it.
Pardon me?
If anyone would like to offer it.
Well, we'll see. Senator Sharon?
Offers the amendment.
Senator Sharon moves adoption of the A15 amendment. Is there any discussion or questions by members of the committee on the amendment? Seeing none, all those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. Senator Dibble?
Great. Thank you, Mr. Chair. So Mr. Backus identified as relevant to the jurisdiction of the committee pretty much the whole bill, but also certainly Section 1, which simply states that data collected by the Commissioner of Health is governed by the provisions of 152.33. That's the Section 13 that we just adopted. Some of the definitions, for example, if you look on page 2.27, we have defined a disqualifying felony offense, so various employees, board members, principals of the alternative treatment centers and the like, if they have a disqualifying felony offense, cannot be owners, operators, employees, et cetera. There are probably other definitions that are relevant to the jurisdiction of this committee. On Section 3, we have a section on limitations. This is the limitations of use of medical cannabis in certain places and circumstances.
Why don't you explain that section in more detail to us, Senator?
So, Mr. Chair, so it says that nothing in the proposal, 152.22 to 38, does not permit a person and does not prevent any penalties for undertaking any task under the influence that would constitute negligence or professional malpractice, possessing or using it on a school bus, on the grounds of a school, in a correctional facility. Smoking would not be permitted on public transportation, where a minor would inhale the smoke, or in a public place, including any indoor or outdoor area open to the general public, or a place of employment as defined under this section 144.413. Those are places of employment as defined in the Clean Indoor Air Act or the Freedom to Breathe Act. And it cannot be used if operating, navigating, or being in physical control of a motor vehicle, an airplane, a train, a motorboat, or working on transportation property, equipment, or facilities while under the influence. So those are the limitations on use. The rest of the section has to do with reimbursement for Minnesota Care, and it also, paragraph C says that whomever owns or controls a particular property is not obligated to allow someone to smoke on that property. So that's the limitations section. Then, of course, we went over the data section that we just adopted. Sections 14 and 15 are kind of flip sides of the same coin. So Section 14, Mr. Chair, provides protections for the medical use of cannabis. And it provides a presumption that a patient or a caregiver is authorized to have or to use cannabis under the following conditions. Has the identification card, has only 2.5 ounces, and that presumption can be rebutted if there's evidence provided that possession or the use was not being used to alleviate the qualifying patient's debilitating medical condition or symptoms. Under subdivision 2, a patient or a caregiver who possesses their card is not subject to arrest, prosecution, or penalty, or disciplinary action by a court or occupational professional licensing board. And also if they don't have more than the 2.5 ounces that they're allowed to have. The caregiver who is assisting the qualifying patient, again, cannot have more than the 2.5 ounces allowable to them, would not be in violation of the law for being reimbursed for their costs for helping the patient that they're assigned to, or bringing the cannabis, or it is not a violation to transfer cannabis to a safety compliance facility for testing. That's the places where they go to measure the potency and the purity and the like. It's not a violation of law to compensate an alternative treatment center or safety compliance facility for receiving money for what they do. It's not a crime for them to offer or provide cannabis to a patient or a designated caregiver for their medical use, or to a visiting qualifying patient. And then we have some provisions around the circumstances in which a person from out of state, that's the visiting qualifying patient, and there's a definition back in the definition section of what a visiting qualifying patient is. Yes. And they can possess, again, the allowable amount in the state, and they need to provide some certification from the person back in their home state that they have this for a medical purpose. Provides for the dismissal of charges for a patient or a caregiver who's not in possession of their card, if they're able at a later point in time to produce their card. If they happen to have the substance in their possession, they're charged and arrested and or charged. If they're able to prove they simply didn't have it on their person and they had the allowable amount for the allowable reason, then the charges can be dismissed.
Senator Dibble, is there a requirement that they possess the card at all times? At least at all times that they are using?
Mr. Chair, I don't know. I mean, they're supposed to, but I don't know if we specifically spell out that they need to have it on their person at all times. Of course, it would be smart for them because that's their protection. But no, I think the easy answer to your question is no. They need to have the card in order to qualify for having the substance and using it, but having it on their person, I don't think we have anything that says that in the bill. We provide for some protections for practitioners. Practitioners are doctors, and so it provides their ability to provide the certification, the prescription, without disciplinary action by the Board of Medical Practice or Board of Nursing or other licensing boards, et cetera. However, there's nothing that prevents sanction if they're failing to properly evaluate the medical condition or otherwise violating the standards of care. It also provides protection for lawyers who are providing legal assistance to alternative treatment centers or the safety compliance facilities. They may be helping them establish their business plan, get up and running, get through all the regulatory hurdles and the like, and lawyers are not entertaining legal liability for so doing. Subdivision 7, arrest and prosecution is prohibited for providing or selling paraphernalia.
Senator Dibble, I'm going to back up a second.
Yes.
Just with regard to the subdivision 6 there on legal counsel. The question occurs to me whether or not we have the authority as the legislature even to state what the bill states, given that it's the judiciary branch of the government, the Supreme Court, that establishes guidelines for the discipline of attorneys and proceeds to do so if it's appropriate. So I'm going to ask if Ms. Pontius has any input on that question.
Mr. Chairman, I'm switching gears here. Can you point me to page and line you're looking at?
Page 15, line 31. It's really a separation of powers
Yeah,
question.
Mr. Chairman, yeah, the Supreme Court has the authority to regulate the practice of law and to discipline attorneys, so it could raise questions. Now, it only refers to the Minnesota State Bar Association or other professional licensing association. So I suppose you could, with the State Bar Association, they're not really, there's, a separate entity, so they're not part of the Supreme Court, so you could control maybe what the bar does in terms of its membership or something, but you could not actually affect the Supreme Court's oversight of the practice of law under the separation of powers.
Okay, so this provision might be of some limited scope, since lawyers' licenses are granted by the Supreme Court and they're suspended or withdrawn by the Supreme Court as well.
Yes, Mr. Chairman, I think that's correct.
Senator Dietzig.
Thank you, Mr. Chair. And I'm not pulling it up quick enough, but doesn't the Constitution give us the authority to do certain things, and then we authorize the Supreme Court to deal with judges and attorneys? So does that give us then the okay to do this? I'd have to go pull up research on my bill from earlier.
Ms. Pontius.
Mr. Chairman, Senator Dietzig, it does, but there's a difference between judges and lawyers.
Okay.
And so for judges, the Constitution actually gives the authority to the legislature to provide for discipline, but the legislature then in turn has delegated it to the Supreme Court.
Okay.
Thank you. Senator Dibble, go ahead.
Great. Thank you, Mr. Chair. I think we left off at subdivision 7, which starts at the top of page 16. And it says, no person is subject to arrest, prosecution, or penalty, et cetera, for providing or selling cannabis paraphernalia to a cardholder or to a medical cannabis organization upon presentation of their valid registry identification card or their registration certificate. Of course, that's the person who is purchasing those goods.
Senator, is there any requirement on the part of the provider or seller to verify the validity of the card or certificate prior to selling?
That's a good question, and I think the answer to that question is no, Mr. Chair. I mean, I think they would see the card. I don't know that they would have a special way to permit its validity or not.
Correct me if I'm wrong, but do I understand there is a central registry of all those who have been issued the card? So theoretically, anyway, providers could be given appropriate access to the registry to verify that a card is currently valid?
Ms. Ozzie may have a better answer than I do.
Ms. Ozzie, if you would go ahead and state your name for the record.
And Chairman, members, I'm Heather Ozzie, Director of Minnesotans for Compassionate Care. To answer your question, Senator Letts, yes, the dispensing organizations are required to check the validity of the ID card before they can offer any medical cannabis to a patient. You can find that requirement on line 12.4.
So that's dispensing. That's what people are selling to those organizations.
Relating to the drug paraphernalia, there is no requirement that those sellers would verify an ID card before offering those products.
So the language on line 12.4 and the lines following that require that they make a diligent effort to verify, but doesn't outright state that they must successfully verify.
That's correct.
Is that correct? Senator Hall?
I would just say, thank you, Mr. Chair, that really is a problem for me. I think it needs to be mandatory, I would think, that they verify on that count. I'd like to hear the author's response to that. If we were to change that, would that be a friendly amendment? It'd be 12.6.
Yeah.
And the same thing as on 12.8, instead of diligent effort, must verify.
Senator Dibble.
Yeah, Mr. Chair, I think that would be a good change. This is a slightly different subject because this has to do with the dispensing organizations, the medical cannabis organization requirements. So those are the folks who are making the cannabis available to patients and caregivers. But that being said, so I mean, we can get back to the other conversation that we were having, but I think simply deleting the words "make a diligent effort to" on both lines 12.6 and 12.8 could and probably should be deleted.
And include must verify?
Senator
Would
Hall.
that be it?
Yeah, must verify. Yeah, replaced with the word
must is on the end of line 5. At
Oh,
12.5.
gotcha.
So
So move.
Senator Hall moves on lines 12.6 and 12.8 to delete the words "make a diligent effort to." Is there any discussion by members of the committee about that amendment? Any, Ms. Ozzie, any comments? All right, Senator Hall makes that motion. All those in favor say aye.
Aye.
Opposed? Motion prevails. Amendment's adopted.
All right.
And for members, I'll note that Section 11 also on that page, on page 12, does set up a verification system. And I presume then that would be the system which the providers would access either electronically or by telephone in order to verify the validity of the card or the certificate. Is that correct, Senator Dibble?
Yes, and Mr. Chair, and in the rules section earlier, the Commissioner of Health is empowered to write all the rules and all the particulars around that system, so that it's and in consultation, of course, with law enforcement professionals, so that it's as robust and as tight as it needs to be.
And while we're on the topic of verification, is there a provision in here? Maybe you already mentioned it. Prior to the granting of a card or a certificate to a user, to verify the validity of the medical prescription.
Mr. Chair, I can point to some of those requirements. So if you look at subdivision 19, which is on 4.3, that's the written certification. You read that paragraph. And then I'll point you to, so the written certification means a document signed and dated by a licensed practitioner, that's a doctor, that in that professional's opinion, the patient is likely to receive therapeutic or palliative benefit from the use to treat or alleviate their debilitating medical condition. The practitioner must specify what that is, sign and date, and only do it in the course of a practitioner-patient relationship after the practitioner has completed a full physical examination of the qualifying patient and a full assessment of the qualifying patient's medical history and current medical condition. Mr. Chair, that's written in such a way so as to avoid some of the criticisms in other states. There's some other provisions for practitioners not having any relationship to alternative treatment centers and the like, not make specific referrals, not have any financial interest and the like, responding directly to some of the states that haven't done this work quite as well. And then on line 8.21, where you see that the registry identification cards program is established and all of the particulars and processes and procedures that revolve around folks who can receive a registry identification card. The commissioner shall verify the information contained in the application or renewal submitted and approve or deny an application or renewal within 10 days to a qualifying patient and the patient's caregiver, et cetera. So it just sets up kind of the criteria of making sure that, that there's a strong system of verifying that patients are receiving these prescriptions in good order.
Mr. Chairman.
Senator Limmer.
Mr. Chairman and Senator Dibble, when it comes to the registration card, is there any, tell me what that card would look like. Is that something like a cardboard type card? Is it similar to a driver's license that we have? Does it have a hologram image on it like we have on our driver licenses? Could you explain what that would look like? My concern is that they might easily be counterfeited, and before you know it, everyone has a registration card.
Senator Dibble.
Mr. Chair, Senator Limmer, if you look at line 9.10, subdivision 3, the contents. First of all, the commissioner is empowered to create all kinds of, conditions for these cards, and we spell out a few of those. So name and date of birth, a statement of whether they're a patient or a caregiver, the date of issuance and their expiration date, they only last for a year. A random 20-digit alphanumeric identification number unique to that cardholder, contains at least 4 numbers and 4 letters. Likewise, if the person is a caregiver, they need to carry the random identification number of the patient whom they're assisting, a photograph taken in full face view, directly facing the camera of the cardholder, so it's a photo ID, and no artsy photos to the side, and then only one treatment center. A person can only get their cannabis from one treatment center, and which treatment center that is has to be on the card. And then there's also some provisions, Senator Limmer, Mr. Chair, if the conditions for which the cardholder change, if their practitioner doesn't believe that they would receive benefit any longer, they need to notify the commissioner. The card is then revoked. If the card is lost, it needs to be reported within a few days' time, and then and then the commissioner suspends or makes that card invalid, and then that needs to be immediately communicated out to all of the alternative treatment centers, so someone can't run around with that card and use it for bad purposes. And then a new card is issued with a new unique number. So there's some protections and provisions around changing the status of a card.
Mr. Chairman, Senator Dibble, is there a consequence if someone used a registry ID card illegally or without the proper authorization?
Yes.
Do you have that in your bill?
Senator Dibble.
Yeah, so that would be in the next section after the section that we were just going through. I'll find that for you, Senator Limmer. So that is under violations, the violations section, which is section 17, and that is on page, section 17 starts on page 20. So the number of sanctions for diversion of medical marijuana, et cetera. If you see subdivision 4, the transfer of registry identification card and criminal penalty, a qualifying patient or a designated caregiver who sells, transfer loans, or otherwise gives another person the qualifying patient's or designated caregiver's registry identification card is guilty of a felony and may be sentenced to imprisonment for not more than 2 years or payment of a fine of not more than $3,000 or both. There's penalties for false statements, cetera. So yes, Senator Limmer.
Senator Newman.
Thank you, Mr. Chairman. Senator Dibble, as long as we're on page 20 on the diversion and the criminal penalty, is there a penalty or criminal penalty if the cannabis is given away, there's nothing of value transferred?
Mr. Chair.
Senator Dibble.
The answer to that question is yes. There is no standard that
And Senator Dibble, the reason I ask is that on line 21, it says sells or otherwise transfers cannabis in exchange of something for value, and that would not, in my mind, include, say, a gift or a simple transfer without value.
right. Mr. Chair,
Senator Dibble.
we deleted that in a previous committee, so it's not supposed to be there. So that we had taken care of that, so I apologize. Yeah, so who intentionally sells or otherwise transfers cannabis, and yeah, those words "in exchange for anything of value" should be deleted, so let's re-delete those if we can.
I would so move.
Senator Newman moves to delete line 20.21 to delete the words "in exchange for anything of value." Is there any discussion on the amendment? All those in favor say aye.
Aye.
Opposed? Motion prevails. Amendment's adopted.
On my honor, that was in a previous amendment 2 hearings ago, so it didn't get picked up. So thank you, Senator Newman.
This bill has been moving very quickly through the process, so
Yeah.
there's a lot to cover. All right, go ahead.
All right,
Further
okay,
follow-up questions,
so-
Senator Newman?
Yeah, and then I believe Senator Dibble was back on 16, or page 16, under the arrest for prosecution prohibited. At least I think that's where we left off. I do have a question at line 8, if I may, Mr. Chairman.
Senator Newman.
Senator Dibble, line 16.8 would be a prohibition from arrest for being in the presence of or in the vicinity of medical cannabis. Would you explain that to me? It seems a bit of an odd phrase.
Mr. Chair.
Senator Dibble.
Yes, I think that's one of those boots and suspenders. I think it occurs from time to time, and I'll ask Ms. Ozzie to help me a little bit too. But sometimes some folks just who are in the same room with controlled substances are sometimes charged with crimes, and I think just because someone is sitting with someone who's using cannabis for medical purposes, they should also be exempted from being construed as committing a crime.
Mr.
Senator
Chairman,
Newman.
perhaps Ms. Pontius or Mr. Backus could answer this question, and I truly don't know the answer, but is it a crime in Minnesota to be in the presence of or in the vicinity of a controlled substance?
Mr. Backus?
Mr. Chair, members, not specifically for that I'm aware of now.
Thank you, Mr. Chairman. And Senator Dibble, I'm not going to make any kind of an issue of it. I would just ask you to give some thought to that line as being a very unusual line. I don't really know what the value of it would be. And I would think that law enforcement would maybe be interested in knowing why it's in there. So it was just something I saw and I wanted to ask about.
So, Mr. Chair.
Mr. Backus.
Mr. Chair and members, and maybe on thinking about it a little bit further, I assume that's meant to address a situation perhaps where there's, drugs on the table and it's not quite clear whose drugs they are and if they would try to charge a person with possession based on perhaps close proximity. So I assume that's the intent there.
Senator Dibble?
Yeah, Mr. Chair, that was the point I was going to make. I think if a defender were sitting here, that they would say to you, there are numerous instances where people are in the same room and they are construed to being in control of or possession of the controlled substance, even if it can't be, it's not in their hand, but it's 5 feet away from them. And it happens all the time, it happens every day.
Thank you, Mr. Chairman.
I do have a follow-up on this as well. For line 6 there, 16.6, the arrest and prosecution prohibited for providing or selling it upon the presentation of a valid registry card. Do I assume that's still subject to the restrictions I'm presenting that we discussed earlier, where they have to verify the validity of the card? Well, how would that?
Right. So, Mr. Chair, the answer to your question is no. So we would probably need to figure out how to address that. So this is someone who sells, like, for example, the vaporizers or something like that. I don't think, so this is just any person in the wide world who's selling, we have restrictions on who can sell.
This is just
the sale of paraphernalia. Yeah.
This is just paraphernalia that this line's referring to. Okay.
So your answer is a good one. How do they know that they're not being presented with some sort of fake registry card? So we probably need to make sure that they must validate the validity.
I guess the policy question would be: do we wish to impose that requirement on those who are selling paraphernalia, as opposed to those who are providing or selling the cannabis itself? Correct. Was a distinction drawn intentionally in the drafting of this bill?
Mr. Chair, yes.
Zazi.
Yes, it was. And the reason is that this registry that's been created contains confidential health information from these individual patients. Having the alternative treatment centers, who are also licensed by the commissioner, have access to that data is not a concern. But any, I don't know what we call them nowadays, but these stores all over town that sell the various types of paraphernalia, I think there's some concern about giving those people access to that database.
Every head shop. At least from my day, that's what they were called. I don't know. So I hear. Senator Dibble.
Mr. Chair, I will. This is something that we're thinking about. It is possible that someone who's selling paraphernalia to a medical cannabis user can validate their registry card without having access to public non-private data. Perhaps the commissioner could develop a way of someone just calling up and saying, got a card here, is it legit or not? If people think there's a big enough concern.
Well, I guess that's the question. I'm looking around the table to see if there's a sense that that's a big enough concern that we want to impose that requirement on every retail outlet that's selling paraphernalia. Senator Goodwin?
So that's my question. I'm not quite clear on it yet. Does this then allow anybody to sell paraphernalia? Should that be restricted to those places that are registered to sell the medical marijuana? But is it right now, the way this reads, does that mean that anybody could sell paraphernalia?
I think that's current law. Backus?
Mr. Chair, members, there are provisions in the controlled substance chapter of law dealing specifically with drug paraphernalia. It's a defined term, and there are penalties for possessing it and selling it. But I think as a practical matter, it's kind of hard to prove that up often.
So then my question
Senator
remains, Mr. Chair, if there are penalties right now and prohibitions against selling paraphernalia, will this change that to a point where you can sell paraphernalia anywhere? Anybody can, as long as they
Senator Backus, or Mr. Backus, I assume then if there are penalties for selling paraphernalia, yet if you walk in any, for lack of a better term, head shop, there are pipes and bongs and so on. Are they allowed to sell those because those are items that would have multiple uses, could be used for lawful purposes, and Is that sort of the legal basis upon which those items can be sold by retail outlets?
Mr. Chair, members, and I believe so. And they're kind of, I assume we're talking kind of about the same thing, but we're using different terms. I mean, the drug paraphernalia is the term used in the controlled substance chapter of law. And this is cannabis paraphernalia, which I don't believe is defined in the bill. So I think there's going to be an overlap there, but I'm not 100% sure of that. But if you look at the drug paraphernalia definition in the controlled substance chapter of law, it says all equipment, products, and materials of any kind, except those used in conjunction with permitted uses of controlled substances, which are knowingly or intentionally used primarily in, and then it goes manufacturing controlled substances, injecting, et cetera. So, I mean, there is that mental state that you have to prove for those. So I think it's a question of primarily, as you mentioned, things like bongs and things like that sometimes have other uses.
So I think the question is, do we want to get into regulating the sale of those items that have other uses, other lawful uses?
Mr.
As a
Chair,
part of this bill.
no,
Senator
that's not
Goodwin.
what I would suggest. I was just wondering if this opened that up wider, because it says no person may be subject to arrest, prosecution, or penalty. It doesn't say no person that's currently lawful to.
Mr. Backus?
Mr. Chair and members, I was just looking at the language in Clause 1, and the immunity is only for people who then provide or sell the cannabis paraphernalia to a cardholder under those circumstances. So it's a very limited subset of any kind of drug paraphernalia sale.
So,
Senator Dibble.
just adding to that thought, kind of building on Mr. Backus's statement about having to prove the mindset. So obviously you can go into Electric Fetus and buy stuff. Their argument, of course, is that's used for tobacco, a legal product. It would be easy to prove that someone who's a card holder is not buying something there for tobacco, or it'd be not a very far leap. And so the idea is, if someone does walk into Electric Fetus, buys something to use medical cannabis with, that Electric Fetus would be protected if that person produced the cart in that instance. So I don't think it changes the facts on the ground. We're going to have places like that around town that sell these things. The only difference is some people are obviously buying it for using cannabis, not tobacco. And so in this circumstances, when they hold a card, a proprietor is protected for the purpose of selling that product in that instance.
All right, why don't we move on then? Senator Dibble, where did we leave off? Oh, Senator Hall has a question.
Maybe we should let him complete his going over it, and then I'll come back.
Sure, okay. Senator Dibble.
Thank you, Mr. Chair. Subdivision 8 provides some protections for...
Give us a page here.
I'm sorry, page, line 16.10, so just moving along. So it provides the protections for the alternative treatment centers to do what they are going to be doing, which is those are the folks who are going to be doing the processing, the growing, et cetera, in the locked facilities, possessing, producing, storing, transporting, purchasing their stock, et cetera. Delivering, transferring, transporting to other organizations, providing compensation to the testing facilities, the safety compliance facilities, purchasing from other alternative treatment centers, and of course dispensing, supplying, selling, delivering cannabis, paraphernalia, supplies, educational materials to the patients and to their caregivers, or to other alternative treatment centers. Subdivision 9.
Mr. Chairman.
Senator Newman.
Thank you, Mr. Chairman. Senator Dibble, is there a difference between alternative treatment center as defined on page 16, beginning at line 10, and the dispensary or the treatment centers that deliver the cannabis to the patient? Or are they, it's like a wholesaler and a retailer, and I don't know if they're combined.
Senator Dibble.
So, Mr. Chair, the answer to your question, Senator Newman, is no. The alternative treatment centers are dispensaries. We used to call them dispensaries. Dispensaries have kind of a bad reputation. You think of, I just talked to a young man who was a page here in the Senate, and he lived in Oakland. He said we had 7 of them on my block. So they have kind of a bad reputation. So we try to call them something else so that we're not evoking something in our minds that isn't true. So yeah, the alternative treatment centers are where I, as either a caregiver or a qualifying patient, would go with my card and get my cannabis, and they're growing it and packaging it and that sort of thing as well.
In the same building.
Senator Hall.
Thank you, Mr. Chair.
Senator Hall. In all likelihood, yes. Yeah.
Okay.
Yeah. And of course, there's many requirements around security and protection and all that stuff.
Senator Dibble, is less vertical integration allowed under the bill? So an organization could concentrate solely on growing the cannabis and then selling it to an alternative treatment center for distribution directly to patients?
Ms. Ozzie can help, but I don't think so.
Mr. Chair, members, there's no requirement in the bill that one of these alternative treatment centers fulfill all of these responsibilities. But when the commissioner decides who to license under the Act, and there are a very limited number of licenses available,
55 you said, I think?
55, yeah. He's going to be looking at a variety of qualifications and considerations, including their ability to provide cannabis. Given the geography of the state and the limited number, I think it would be highly unlikely that the commissioner would license anybody who would strictly cultivate or strictly manufacture these products.
Senator Dibble?
Mr. Chair, that has to do, of course, with the limitation on the number that are allowable. I didn't get into it in great detail, but based on population, a given county can only have so many. Counties below 20,000 would have none. I think between 20 and 300,000, they would have 2.
One.
I'm sorry. Between 20 and 300,000, there'll be 1 facility. 300 to 1 million, there'd be 2 facilities, and above 300,000 people, there'd be allowed 3 facilities. So we wouldn't get to the 7 per block. So there'd be a limitation. But that, on the flip side, of course, creates an access issue for folks who are out in far less populated parts of the state. And so we're trying to strike that balance.
Okay. I can just imagine the company may wish to specialize in the production and packaging, but not be interested in the retail distribution, if you will. And that's possible under the way you've set it up here, but not necessarily the way that ultimately the licenses might be given out.
Mr. Chair, that's correct. Because the 55 limit would still remain, so someone who is not providing at retail would still take one of those slots.
That's a little bit beyond the judiciary's questions, but I guess part of it has to do with the ability to enforce the restrictions that are set forth in the bill. I understand you've drawn it pretty tightly, but I could envision at least market forces in which you'd have 1 or 2 operations that might wish to specialize in growing cannabis and maybe even packaging it, and have no desire to distribute directly to the patients, and other organizations that might prefer to specialize in distribution directly to the patients.
Yes. See what the market brings us. So, are you suggesting a trip through commerce? I hope not.
We're in their room.
Okay.
Senator Dibble.
So moving to line 6.30, safety compliance facility provides a great deal of the similar protections that you see up above in subdivision 8 for the alternative treatment centers, the acquiring, transporting.
I'm sorry, I did have a follow-up question,
yes.
if I may. Senator Dibble, this might even apply to the safety compliance facility, but if I'm reading the language correctly, it says that the alternative treatment center is not subject to search or inspection except by the commissioner. So is this saying that individual law enforcement agencies are not allowed to search or otherwise inspect these facilities if they suspect unlawful conduct is occurring?
Mr. Chair, I don't think that is the intention. Ms. Ozzie, can you? Yeah.
Ms. Ozzie?
I believe that would be the consequence, Mr. Chair, yes.
So the enforcement would be solely by the commissioner, this Commissioner of Health, right?
That is correct, yes. And the Commissioner of Health has the authority to inspect anytime he likes.
Okay, and then what, setting aside the question of whether or not a law enforcement agency should have the authority on their own if they suspect unlawful conduct to inspect, but what does the Commissioner of Health do if they suspect that unlawful conduct is going on? Can they bring in a law enforcement agency? It looks like under the language here, maybe they couldn't even do that.
Mr. Chair, they would be required by law then to notify law enforcement of an apparent violation of the law, yes.
And then, once they notify law enforcement, what rights under this statute does law enforcement have to follow up with search and inspection? Or the county attorney with prosecution?
Well, I think that's a very good question. The commissioner has investigative authority and authority to hear and investigate complaints. So presumably the complaint would begin within the department.
I think we've got to wrestle this one around a little bit here.
Yeah.
Senator Limmer?
Mr. Chairman, do we restrict law enforcement from investigating crime or barring it from a particular agency simply through a bureaucratic reference? I don't know of anyone or any instance that if law enforcement has probable cause to investigate a crime, and if that meant a potential search or seizure, of course with a warrant involved, I've never known. I mean, that's why we have that established in law. I'm surprised that we would have a reference only limiting a potential illegality investigation to an agency that is not law enforcement. It's regulatory, I can give you that, but I'm a little concerned that we would bar or at least create the confusion that we would bar law enforcement from doing the job if they suspected under a probable cause standard that they needed to step in and investigate or seize evidence. I don't know how to, I don't have an answer for it, but I am concerned about the way the bill is written.
Senator Champion?
Thank you, Mr. Chair. Perhaps I would ask the chair to inquire of Mr. Backus, because it's my understanding what is articulated herein is consistent with pharmacies. So if there's a belief that something is going on in a pharmacy, be it someone taking drugs or doing anything illegal, I think that comes as a result of an inventory that happens at the pharmacy internally, and then they can then call in law enforcement, if need be. But I don't think law enforcement has the ability just to go into a pharmacy and start, investigating something independent of having the consent of the pharmaceutical element of even Walgreens. Let's say that for an example. But I'm not the pharmacist. My wife is the pharmacist, so perhaps we can ask Mr. Backus to give us some guidance around that.
Call your wife.
Maybe I should call my wife.
Your wife. I suspect with a warrant, if they otherwise develop probable cause that there was something fishy going on, illegal conduct going on in the pharmacy, then they could obtain a warrant and then go in and inspect. I suspect.
Mr. Chair?
Senator Limmer?
Mr. Chair, Senator Champion raises an interesting question. Do the dispensaries that are referenced in the bill, are they under the auspices or the legal requirements of pharmacy rules and regulations, or I thought we were kind of creating a little bit of a hybrid supplier for legal use, and that's why we didn't use pharmacies as a distribution point.
Senator Dibble may have an answer.
Thanks. I'll respond to that, but then I think I can help us with the original question that's at hand. So the answer to Senator Limmer's question is no, or yes. No, these dispensaries are not subject
Would you please clarify?
To the Board of Pharmacy. And yes, we're trying to create, the short version is, the pharmacies, they can't dispense this substance because of federal restrictions, et cetera, and all the regulations that they exist under. So we do need to create this alternative form of distributing the product. That's the reason why we go into all of this elaborate detail. I do want to, as we read further and tried to figure out why we put this language in, let me first say that the purpose of this language, the spirit and the intent, is to avoid unwarranted, undue, improper attention and scrutiny by law enforcement personnel. That's based on experience in other states where other law enforcement agencies really have created a lot of trouble in a way that really isn't justified for these alternative treatment centers, for dispensaries. So we're trying to avoid that sort of behavior, that sort of treatment. Harassment is what's been going on in other states. And so that's the intent. And so what the language says, you have to read all the way to the bottom of the paragraph. It says, not subject to prosecution, search, inspection, except by the commissioner, et cetera, for acting pursuant to sections 152.22 to 152.38 and the rules that the commissioner is authorized to promulgate. So what the paragraph in total reads is that if the alternative treatment centers are playing by the rules, obeying the law as set forth in the proposal, then unwarranted investigations, et cetera, really shouldn't be going on. That's the intent. I don't think there's any restriction on law enforcement from conducting appropriate investigations, conducting inspections of premises, doing whatever it is they need to do, if in fact they have reason to believe that an alternatives treatment center is not acting pursuant to sections 152.22 to 152.38 and the rules that the commissioner has promulgated. So that's what we're trying to achieve.
Senator Newman.
Thank you, Mr. Chairman. Members, it seems to me that the short answer to this question is that the commissioner should be given the jurisdiction and the authority to investigate violations of the licensing and the regulations that go along with this new system. But certainly an explanation that law enforcement should not be given the authority to prosecute, to execute search warrants, et cetera, for fear that law enforcement is going to misbehave, in my mind, is not a very adequate explanation. And I certainly would not be in favor of trying to statutorily prohibit law enforcement from investigating criminal activity if they believe it is going on independent of something that the Commissioner of Health has discovered. And when I read this statute, this bill at line 131, it pretty clearly says that this agent is not subject to prosecution, search, or inspection except by the Commissioner. And that's pretty straightforward language, I would think. So my suggestion would be is to empower the Commissioner with the authority for inspection when it comes to the licensing, i.e. the civil aspect of it, not the criminal aspect of it.
Well, Mr. Chair.
Remove those two other ones. Remove prosecution and search.
Senator Dibble, I'm consulting with counsel about how we might make the language more clearly focused on what your intent is without limiting appropriate law enforcement investigations.
Well, maybe, Mr. Chair, maybe a sentence that begins as such, nothing in this shall be a limitation upon law enforcement's ability to enforce the law, or, you know.
And then maybe then clean up with this.
Yeah.
Okay,
Mr. Chair.
we'll work on some language to that effect that we can come back to. Senator Hall?
Thank you, Mr. Chair. I submit on line 16.31, if we just remove prosecution and search, would that be enough?
15 what?
1611. There's identical language in subdivision 8 and 9
Okay.
that would have to be cleaned up. So Mr. Backus is contemplating precisely how to do that. So why don't we let him work on that, and we'll circle back to that, members, okay? Senator Dibble, you want to move on then?
Sure. So I think we had touched on the safety compliance facilities basically having roughly the same protections for conducting the business that they're tasked with providing. Moving on to 17.13, subdivision 10. Any interest in right to property that is used in conjunction with the appropriate use of medical cannabis is not forfeited, so it's exempt from the forfeiture laws.
Mr. Chair?
Senator Hall.
On that 17.15 where it says, or acts incidental to such use is not forfeited under this section. What is the incidental to such use? I mean, I'm afraid it could be a forfeiture-free card. How does that work?
Senator Dibble.
Well, Mr. Chair, I think that would be a stretch to say it's a forfeiture-free card. It's folks who are going to and from picking up cannabis on behalf of their caregiver. There has to be a nexus to the medical use of cannabis, and I think if it's outside of that and can be shown as such, if you're violating the law and using and benefiting from drug trade, et cetera. And that's proven. I think we just tightened those standards. Was that Senator Limmer's bill? I can't remember. Anyways, tightened our forfeiture laws. Did you do that, Senator Limmer?
Senator Thompson carried.
Oh, Senator Thompson, yes, Senator Thompson.
That was a co-op.
Senator Limmer supported.
I did too.
Okay.
So, anyways, I think incidental. There's a nexus with medical use of cannabis. So I think that's the intent. But thank you for the clarification.
Thank you.
Some modest discrimination provisions. So folks can. Rent. If they're users of medical cannabis, they can rent a place to live. They're not automatically disqualified from the organ transplant list. They're not automatically not hired unless there's a condition of employment that relates. That also applies to folks who are designated caregivers, some modest anti-discrimination provisions as well. So similar provisions for caregivers. And then we have some protections for custody and visitation rights for parents who are medical users as well. There are exceptions unless the person's behavior is such that it creates an unreasonable danger to the safety of the minor as established by clear and convincing evidence. And then there's a card as probable cause section.
Mr. Chair?
Senator Hall.
Back, if we would, Senator Dibble, to Section 11, 17.21. The paragraph does not prevent a landlord from prohibiting the smoking of cannabis on the present premises. Would the landlord be able to prohibit people from being high on his premise?
So
Mr. Backus?
Mr. Chair and members, I didn't hear the exact question, but I was just explaining to the chair that the bill does make a number of distinctions between, say, smoking the cannabis in certain places versus otherwise ingesting it. So I think that would be limited to smoking there. That I assume the other authorized ingesting of the cannabis would not be prohibited under there.
Okay, yeah, the question, Mr. Chair, Mr. Backus, is does a landlord have the right to tell someone that's high that he cannot be on the premise?
Where are you looking?
Not sure if a landlord can do that now.
No,
Yeah, I don't know.
Mr. Backus? It's beyond Mr. Backus's scope of expertise. Yeah, I'm not sure. Landlord could prohibit use of illegal drugs on the premises, but if one were to use it off premises and come home, be under the influence of it, I'm not sure landlord...
Depends on their actions, I assume.
I would depend on their conduct. I don't know that just the status I can the present law would be effective.
Thank you.
Yeah, and actually, yeah, it's actually not a violation of criminal law to be under the influence of an illegal substance. If the substance is on you, in your possession, that's illegal. Might be a felony.
What about if it's
even
in
a trace of it? But if it's in your bloodstream, that's not.
No. If it's in you, like you ate it.
It's in your stomach?
Yeah. Then it's in possession, isn't it? We can go on. Mr. Chair.
Well, if it's in a balloon.
Yeah, but not in a bottle.
Ooh.
All right, we won't get into stomach contents. Going to Schmerber, couldn't we? Is that Schmerber or Schneckloff? What was the? There was a major Supreme Court case on search and seizure involving pumping stomach contents. If you have probable cause to believe it was a case, and that there was a warrant was required to do certain things, but there was an exception to the warrant requirement that was found.
And Mr. Chair, as Senator Sharon said, if it was in a balloon, they were trying to hide something. Yeah, I understand. Same thing.
Yeah, well, it's got its own body of law. Probably don't do that.
How do you know about those guys?
Pun intended.
It's my professional responsibility.
All right, let's move on.
Okay.
Senator Dibble.
Okay, so looking at 18.10, Mr. Chair, having a card does not constitute probable cause, so it doesn't trigger the ability automatically for the police to search your person, search your property, et cetera. Moving on to Section 15, provides for Mr. Chair, this provides for a set of defenses for folks who have medical cannabis prior to the issuance of their card, but they do have the prescription from their practitioner. So this was, and the intention of this section, Mr. Chair, there's a couple of intentions here. One is the bill itself goes into effect, if it were to pass this year, would go into effect July 1st of this year. But the whole system of establishing the cards, et cetera, isn't going to be up and running until July 1st of next year. So this provides for a window of time for folks to have a small amount of usable cannabis yet this year, if the committee agrees that that's a good idea. It also allows for the window of time after July 1st of next year. It obviously would take a certain amount of time for the card to mailed to them, but if they have the statement from their doctor, the prescription from their doctor, then they have the ability to, and they're found with the medical cannabis and charged, that they would have a defense available to them. And so this sets forth those conditions under which they can provide that defense. But they have, of course, like I said, the prescription. After the assessment, it's no more than 2.5 ounces.
Okay, Senator Dibble, I'm sorry, there are a couple questions here. Senator Newman?
Thank you, Mr. Chairman. Senator Dibble, to Section 15, your explanation that this section is apparently in play because the cannabis would be available before the cards were actually issued, and that explains. You just answered several of the questions that I had with respect to this, and that would also, I assume, explain why the affirmative defenses section expires on July 1st, 2016. Am I correct?
Correct. Mr. Chair, Senator Newman, correct.
Yeah, and Mr. Chair, if I may, one follow-up then. So tell me if I understand this correct. The bill that you are proposing would be effective in July of 2014. Cards would be issued, I assume, in July of 2015?
Correct.
Is that correct?
Correct.
And so we are going to be with us in a situation for a period of about a year where cannabis would be available to people without the card, but on or with a doctor's prescription or whatever it might be. If I got it straight?
Mr. Chair, Senator Newman, that is correct. That is the goal of this section.
All right, thank you for that explanation.
Senator Hall.
And Mr. Chair and Senator Dibble, following up on Senator Newman, so they're going to have either prescription or card, but in this prescription and card time before the dispensaries are or centers are available, who are they buying the product from? And would that be legally?
Right.
It sounds like they wouldn't be able to do it legally, so now we're almost encouraging illegal activity because we don't have it in the dispensary yet?
Senator Dibble.
Yeah, Mr. Chair, that would be a perspective, yes, that one could have, yes. Yeah, I mean, there's only certain places where folks can get the substance today.
Senator Hall, follow-up?
Yeah. I'd like to hear Senator Newman first.
Senator Newman.
Yeah, thank you, Mr. Chair. To follow up, Senator Dibble, then if there's this period of time of say, approximately 1 year when the cannabis would be available without the card, now I assume that the purpose of the card is for identification purposes. So for the purposes of that 1 year, what assurances do we have that the person with the prescription is the person that is the patient or the caregiver or whoever it is that is supposed to have this cannabis available to them? Wouldn't the prescription and the identification card need to go hand in hand so that we wouldn't be put in a position or even put law enforcement in a position of this system being abused?
Well, Mr. Chair, I mean, I think folks do need. I mean, so folks do need to have, the prescription. So that's that start to set that forth on line 19, they would have to, of course, in some other form or fashion, prove who they are. This of course, would only this section would only go into effect or be invoked if someone, in fact, has been arrested. They're in court. They've been charged with a crime. They need to provide a defense of some sort. They produce their prescription and/or their doctor, showing up saying, "Yes, I wrote this. This is the result of a full medical examination as a part of the provider-patient relationship, et cetera, and and this person is who they are." I mean, so at that point, their identity has been well established. This is several steps down the path. They've been arrested, they've been charged, they're in court, they're trying to defend themselves from charges.
One follow-up.
Senator Newman.
Just a follow-up thought, Mr. Chairman and Senator Dibble, that it would seem to me that from the standpoint of law enforcement, from the standpoint of whoever it is that will be the individual that is dispensing the medical cannabis, I can think of a myriad of questions to ask about the dovetailing of the identification card and the doctor's prescription. And it seems to me that the two of them have to go hand in hand, or we, law enforcement, the dispensary folks, et cetera, aren't really going to know who the cannabis is being delivered to. So it's just a thought, Senator Dibble, that it feels like a rather significant hole in the bill to me.
Well, Senator Dibble.
And Mr. Chair, that's why I wanted to have a thorough airing and discussion, because it does trigger a significant number of public policy concerns. Our goal, of course, is to get relief to people as quickly as they can. We're caught on the horns of the dilemma, of course, that it's going to take a while for the commissioner to write rules and establish the regulations, get the computer systems up and running, get the cards issued, and that sort of thing. It may be the opinion of this committee that this is a bad idea, but our goal is to get relief into the hands of those who are suffering as soon as possible. It's hard to reconcile some of the issues, though, that are being raised.
Senator Hall.
Thank you, Mr. Chair and Senator Dibble. I would agree. I think we'd all empathize with those that want this done as soon as possible. But looking at, the cards, the prescription, the dispensary, to me, until all of that comes together, and I know you've done a lot of tightening up, Senator Dibble, on this, and I give you a lot of credit for that. But I think this is one that I would assume that the public safety would have a very hard time with. And I don't think we want to get to the point where we're prosecuting people and then, pulling out the cards and saying, well, I have my prescription here or whatever. I think it needs to start when everything's ready. And I don't know how that is, but I guess I'd ask Mr. Backus, would it be, knowing what I'd like to do there, would I just have an amendment to remove Section 15? Or is there more to 15 than that aspect?
Mr. Backus.
Mr. Chair and members, I think based on the concerns you were raising, that would be your remedy, and is to delete that if you were uncomfortable with that kind of interim period of providing essentially a defense.
Senator Dibble, I'll circle back, but Senator Dibble, on line 1911, it provides that this whole defense is only available after a person, if the arrest or citation occurred after they had submitted a valid application to qualify for the registry, correct?
So, Mr. Chair, there are two instances, I believe, in which this section applies, this affirmative defense opportunity applies. The first is in paragraph 1 right above that, so after July 1st of 2014, and so the application, for the better part of a year would not be available to them. And then, yes, the answer to your Section 2, yes. I mean, if someone has applied, but the card hasn't been received yet. So Section 2 would essentially go into effect July 1st of next year. So they've applied, but they haven't gotten their card in the mail to them. But in the meantime, they have a small amount for the purpose of medical treatment.
So, Senator Dibble, when is the date that you expect the applications to first be available for registry?
Mr. Chair, so the cards, the bill requires the cards to begin being issued July 1st of 2015, and so applications for cards, I can't say with specificity, but sometime before that, a matter of weeks or months.
Okay, but your main goal here is to bridge the gap from when the medical use would be allowed July 1, 2014 until July 1, 2015, or whatever short time period before that is allowed to accept applications.
Yes,
Is that right?
Mr. Chair.
Okay. Senator Hall, follow.
Thank you, Mr. Chair. Yeah, my concern would be that we aren't causing people to get illegal drugs. That when the dispensary is ready, I don't really care when that date is. When they've got their card, they've got their prescription, and the dispensary is there, so everything's legal, that's tight to me. And I think the public is looking for us to make sure this is tight.
Let me suggest, I mean, this would be a rather significant change, and I suspect that the proponents and opponents would like to
Speak on it.
speak to this question before we made any decisions on this topic. So let me suggest that you hold the thought on whether or not you want to offer such an amendment until after we conclude going through the details of the bill, and we hear the testimony, and then we can revisit the question.
Thank you.
Fair enough?
Yes.
Senator Newman?
Yeah, fair enough, Mr. Chairman, and if I might just direct Senator Dibble's attention to the two lines that he was just talking about, beginning 19.9 and 1911. That's the two issues that you were just talking about, Mr. Chairman. And it looks to me like what would validate the availability of the cannabis after the application has been submitted, but before it's been approved. That's the way I'm reading those two lines. And that seems to me would be problematic. And maybe, Senator Dibble, if you had some language that would indicate that the application has been approved, but the card is not yet available. So just a thought.
Right. So I appreciate the thought, and Mr. Chair, just to be clear, I respect the perspectives that have been provided on this. You know, I understand the problems that this issue might raise in some people's minds, some of the committee members' minds, and I fully understand and respect those concerns. I have similar concerns, hence the reason for the bill. The fact is, the reality today is that, you know, a lot of folks are getting marijuana for medicinal purposes in ways that we wouldn't want them to. So that's, you know, so we're just trying to provide some defense in court if that's the circumstance that they're in over the next year and a half until this regimen is fully established and operational.
And so maybe some way to think about this also might be, if we choose not to delete the whole thing, maybe tighten up the language in the first provision as well, something just theoretically to consider.
If we can do that.
Okay. So why don't, Senator Hall, why don't you think about how you might want to approach that, and why don't we move on for the moment. Oh, I'm sorry, before we move on, though, I want to back up for a quick second, if we might. On page 18, line 10, subdivision 12, card as probable cause. Can you help me understand what the purpose of that was, in particular with regard to a person who, you know, is not someone who's not the named card holder, but who's in possession of the card? How does that work? I mean, is the idea here that merely possession of the card not be probable cause or give grounds for a search for anyone who's in possession of a card, or only for the person who's supposed to be possessing the card? And is there any criminal penalty for someone possessing or using a card that was not issued to them?
So, Mr. Chair, the answer to your question is the intent is that possession of the card should not be probable cause if that card is in the possession of the person to whom the card belongs. So that's the answer to the first part of your question. So if we need to make that more clear, we should do that. It's a good catch. Secondly, I don't know the answer. Need to look into the violations section. Are you looking?
There is a penalty.
Yeah, there is a penalty if you have a card and you're using it to acquire cannabis. Where is that?
I think you got it right.
So you can't, that's a good question. I mean, so there's a penalty for getting marijuana for, for purposes other than medical use. So that's established in law. If you look on 20.25, a qualifying patient or designated caregiver who sells, transfers, loans, or otherwise gives another person the qualifying patient's or designated caregiver's identification card is guilty of a felony. So the person to whom the card belongs, they cannot give that card to someone who shouldn't have it, and for the purpose of acquiring cannabis. I don't know that we have a special provision, though, for that person's use of the card beyond acquiring marijuana illegally. That's already illegal. Well, except that in a more general sense, in subdivision 3, anyone who intentionally makes a false statement to law enforcement about the facts or circumstances relating to the medical use of cannabis to avoid arrest, etc., is guilty of a misdemeanor. That would be in addition to any other penalties that already exist in law.
So I think one question is to consider whether we want to make it a separate penalty for someone to possess a card that does not belong to them, or if we just want to possess and to attempt to use it to unlawfully obtain it, make that a heightened penalty over just someone who doesn't possess a card and tries to buy cannabis illegally.
Mr. Chair, I'd be very comfortable if someone was possessing a card and using it to acquire cannabis, and they shouldn't be doing so.
And I'm not sure I'm comfortable with just the concept of criminalizing mere possession of the card. I mean, they might be just carrying it from one place to another on behalf of someone else, and that alone I'm not sure I'm comfortable with, but it's a thought. But certainly attempting to use it then to obtain cannabis, I think it does more damage to public policy than merely not having a card and attempting to buy cannabis on the street or something. If they're going to a dispensary with someone else's card trying to get it for themselves, I think that poses a greater problem to the whole system that's set up here.
Mr. Chair, I agree.
So maybe we could ask counsel to draft a new criminal penalty for that purpose.
So I have two ideas, Mr. Chair. One is making sure that the probable cause is confined to the valid card holder, the protections on probable cause, and then this other idea, someone using a card who shouldn't be.
Just make the list of things we'll come back if you want some time. Okay. All right. So we've identified a couple of points to come back to, and we're going to let Mr. Backus think about some language that would implement those thoughts. Fair enough? We'll just make sure we circle back.
Mr. Chair.
Senator Limmer.
One other area that we might want to discuss is on page 17. This goes back to the landlord relationship with a person that would be leasing property. You might recall that for landlords who own a 1 to 3 unit building who happen to live in the building itself, they're allowed to legally limit the type of individual that would be leasing from them. I'm not sure if that's something that we should consider in this, but it's certainly allowable under law. And I'm wondering if I could see where a landlord who happens to live, let's say, in a duplex, just doesn't want to be around perhaps the smell of marijuana being used in a unit that's in the same building. And we certainly allow landlords to prohibit other lease leasors or leasees to say no to a potential renter for a variety of reasons. And I was just wondering if Senator Dibble had considered that same reference in writing this bill or not. And I was wondering if Senator Dibble had thought of that in recognizing other existing prohibitions on I guess legally discriminating would be the word, but it's narrowly drafted for those who live in the unit that they're renting out.
Senator Limmer, certainly with regard to your concern about smell, or at least smoke that causes smell, there is a provision that allows the landlord to prohibit smoking on the premises.
Oh, it does.
Already in the bill.
All right.
Was your concern beyond that?
No.
Okay. All right, so where did we leave off? Senator DeBoer, in describing the bill to us.
So, Mr. Chair, so the next relevant section, I mean, we have some of the operational considerations in the revocation of the certificates and the, all the circumstances under which either the organizations or the individuals can no longer participate in the program, if they break any of the rules. I'm not sure if you wanted to get into the details around that. The next section identified by Mr. Backus is the violation sections, which we had touched on a little bit when we were hopping around on some questions, but I can go back over those quickly.
Go ahead, Senator Tim.
If a patient or a caregiver or an organization fails to provide notice, and these are various notices that you find a little bit further back in the previous part of the bill, 152.27, which you can find on page 10, so that's section 7. So there are a number of circumstances in which either a caregiver or a patient themselves or an organization or a practitioner needs to provide notice to the commissioner about a change in circumstances. A card has been lost or stolen, or the practitioner believes that the patient could no longer benefit from the medical use of cannabis. A number of different notices that are required to be provided to the commissioner on a timely basis, and if they fail to do so, they are guilty of a petty misdemeanor. Subdivision 2, starting on line 20.11. This is in the diversion of cannabis, applying an additional criminal penalty. And that's a felony, 2 years in jail or $3,000, or both. And also, you cannot continue to be affiliated with a cannabis organization. So that's in the instance of the organizations. Cardholders, we did that little cleanup. Thank you, Senator Newman. Cardholders likewise cannot divert cannabis. Also guilty of a felony, 2 years in jail, $3,000, or both. Then we have the provision around transferring a card, and by a patient or a caregiver, guilty of a felony, again, 2 years or $3,000, or both. False statements to law enforcement officials about facts or circumstances relating to medical use of cannabis, guilty of a misdemeanor, possible jail of 90 days, fine of $1,000, or both, and that would be in addition to any existing penalties that would be under law. And then you're disqualified from further participation in the program. When you are looking to certify yourself as a medical cannabis organization, and you submit false records or documentation, and guilty of a felony, similar sanctions. A practitioner, so a doctor, who refers, I talked about this a little bit earlier, so a doctor who refers a patient to a particular alternative treatment center, or to a particular caregiver, who advertises for their services with the medical cannabis organization, or who has a financial interest in one of the medical cannabis organizations, is guilty of a misdemeanor, possible prison, and a fine. So that's trying to address some of these abuses by some of these happy doctors in other states. We provide for protections around the confidentiality of information. In Subdivision 8, we want to be sure that there are no breaches of private, not public, confidential data. And then a kind of a general, if you're breaking any of the rules that are established in 152.22 to 152.38, you can be fined up to $1,000 in addition to other penalties specified by law. So that's the violations section, Mr. Chair. I think we were going to work on when someone has a card that shouldn't have a card and they acquire marijuana.
Yes, and
With that
Mr.
card.
Backus has some suggested language for that one.
Mr. Chair, members, there are, as far as I know, there are 3 amendments I'm tracking, and there are 2 that we could maybe dispense with now. The first is on page 18, line 11. This is the discussion about essentially the valid use or valid possession. So the amendment would be after card on line 18.11, insert by a person entitled to possess or apply for the card.
Could you say that again?
Yes, Mr. Chair and members, after card on line 18.11, insert by a person entitled to possess or apply for the card.
Senator Dibble?
Mr. Chair, that sounds agreeable to me.
I'll offer that as an oral amendment.
Senator Sharon so moves. Any discussion on the amendment? All those in favor say aye.
Aye.
Aye. Opposed? Motion prevails. The amendment's adopted. Mr. Backus?
Yes, Mr. Chair, members, on on page 20, on line 28, so 20.28, after card, insert or a person who without authority uses another's card. So that would address the issue again of the person essentially wrongfully using someone else's card. And that would be a 2-year felony.
20.28 after card.
So, members, it does not address the question of possession of someone else's card. And I was trying just to conjure up reasons why someone might possess someone else's card. And I don't know that I have time to think of all the scenarios now, but I'm not sure that I'm ready to go
It's a utilization.
to criminalize possession, but the use of someone else's card is a whole different story. Senator Dietzig?
Mr. Chair, so an example could be if you're helping to move somebody, literally move people, and if it's an elderly person, they could be moving into a nursing home or something. I mean, they may have documents that they don't want to lose and box up. So you may have possession of that while you're moving them. And so, you're moving them, you're not attempting to use it, but you are literally moving them.
Or caregivers in the facility that are moving their personal
Right.
property around.
Yeah.
Keeping it for them in a facility.
Right.
Safe deposit box or something like that. Senator Sharon?
I'll make this oral amendment as well, on line 20.28.
Mr. Backus, would you please repeat the amendment?
Yes, Mr. Chair and members, on line 20.28, after card, insert or a person who without authority uses another's card.
Any further discussion on that amendment? Senator Newman?
Would that entail or pick up someone who wants to use a card?
Mr. Backus?
Mr. Chair and members, I think then that would be an attempt to commit the crime, so the attempt laws would then apply.
Senator Hall?
Mr. Beckers, would you read that one more time?
Mr. Chair, members, line
Mr. Beckers.
20.28, after card, insert, or a person who without authority uses another's card.
Any further questions or discussion on this, Senator Sharon's amendment? All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment's adopted. All right.
Mr. Chair?
Senator Hall.
I would suggest that we listen to our testifiers, and they may have a reason that we would want to do someone that's just possessing, but I can't think of one.
Certainly, anyone who testifies who wishes to address that point, Senator Hall raised, welcome that testimony. Senator Sharon?
Are we pretty much through the bill now?
I believe that we are.
Because I have a question that's really not related to the discussion at hand, so I want to wait on that for Senator Dibble before the testimony, but I'll wait until you're through the areas of law that you're reviewing now.
Yeah, thank you, Senator Sharon. I think we'll go into the fee and fiscal aspects of it after we hear other testimony. But before we go into the testimony from individuals, if you want to ask a question, now's a good time.
Yes, thank you. Senator Dibble, one of the things I'm trying to track here, I know that these facilities that, I can't remember, I don't want to call them dispensaries, I can't remember the term anymore.
ATCs, alternative, yeah.
ATCs are not treated like pharmacies. And I know that in the bill, a person has to get their certification with the signatures from a physician affirming that there is an appropriate purpose for which this prescription will be made. I know that they have to present that at the alternative treatment site. And I know that there is much in the bill that tracks the person who is purchasing and making certain that the person who wants to have access to this is following their procedures. But I don't see, and because it's not under the Board of Pharmacy, how and if there is a tracking through the prescription monitoring program of the prescribing practices here or the utilization practices for us to really be able to determine what's happening from a prescribing perspective. I know that there is restrictions in the prescription monitoring program not to, we follow someone's, in that program, the prescriptions that a patient gets, and we try to track that so we can pick up on opioid abuse and stuff like that. But in this instance, is the prescriber, who is a physician, has to, do they have to be the treating physician for the medical diagnosis? Do they have to have an ongoing treating relationship with the person? Or can I be treated by a different physician, know a physician who's willing, because I have a diagnosis, be willing to offer me this prescription, and then I go back to my non-prescribing physician who is treating my medical condition that's allowed under this bill? It is a concern that I hear out there that you get identified persons who are legitimate prescribers as being identified as the person to go to for this prescription. And what if we're outside of that prescription monitoring program and outside of the Board of Pharmacy processes, how should we be thinking about that? And one of the things I was trying to look for is if there's something in the rulemaking or if there's some other process that's in place here. I see that there's some reports, of course, that come back to the legislature. There's an evaluation process that's being established to determine patient outcomes, legal difficulties, what the actual impact of this legislation has. So I'm just trying to figure out if there's a place where we're going to try to process and see if we set up a situation where we have identifiable prescribers who everybody goes to for this prescription and then goes back to their own caregiver.
Senator Dibble.
So, Mr. Chair, I think we addressed that in a couple of different ways, and I think Ms. Ozzie probably will be able to answer the question better than I will. But Mr. Chair, Senator Sharon, of course, the written certification and its requirements are kind of captured in the definition of what a written certification is, and you find that on page 4.3 to 4.11, and where it says that the practitioner needs to state in their professional opinion, and I do think Board of Medical Practice has some authority over the activities of physicians. We confined it, of course, to MDs and NDOs. So in their professional opinion, the patient is likely to receive benefit and must specify what that is, sign and date, and only do so in the course of a practitioner-patient relationship after there's been a full physical examination, a full assessment of the patient's medical history and current medical condition. So I think that goes a good ways or part of the way towards addressing some of your concerns. Again, I think the commissioner is authorized to notify the Board of Medical Practice if there's reason to believe that a practitioner hasn't complied with those requirements. You see this on line 13.28, paragraph 5. If they haven't done the full assessment, evaluated the medical history, the current medical condition, or is otherwise reason to believe that the practitioner has otherwise violated the standard of care. Did you have more to add? She went to the cards. Some aspects of the card.
Ms. Ozzie.
Yeah, and as you begin to answer, but there is not really a way in which we're able to track the prescribing patterns here to determine if there is a prescriber that is being targeted for most of the prescriptions.
Senator Dibble.
Mr. Chair, another measure that we talked about just a few minutes ago in the violations sections was to make sure that these physicians are not referring, so it's kind of separating the interests quite a bit. That's been the source of some of the problem in other states. So they don't have an interest, a financial interest in a particular dispensary, ATC, that they're not referring to specific ones, that they're not advertising in those dispensaries, either in their facility or in their materials or that sort of thing. So we do kind of get down that path. But to answer your specific question, is it a part of the prescription registry? No, it doesn't participate in that.
Senator Dietzick.
Thank you, Mr. Chair. And along that line, I know what so on 1524, this is the same thing. A practitioner may not be subject to arrest, prosecution, or penalty in any manner. And then it goes on to based solely on providing a written certification or otherwise stating that his professional opinion, their professional opinion. So that I can't be if I'm the doctor, I can't be prosecuted for writing that, prescription, we'll call it. But what if, does that give me immunity, and this might be to Mr. Backus, does that give me immunity if we find that I am the doctor, the pill mill doctor, and I'm writing, or is that under someplace else? I'm the one writing all these multiple prescriptions that maybe aren't, I'm abusing that privilege, and maybe some of them, they're not either not evaluating the medical condition or they're just saying, yeah, you've got the problem, and they're writing the prescription. Does that give the doctor immunity?
Mr. Backus, how do we deal with Dr. Feelgood?
Yes.
Oh, Mr. Chair.
Senator Dibble.
So I just, again, this kind of just reiterates some language that I pointed out in another part of the bill, but it does say, again, this is in the protections section, but it does say that on lines 15.27 to 15.30, nothing in in this proposal prevents a professional licensing board from sanctioning a practitioner for failing to properly evaluate a patient's medical condition or otherwise violating the standard of care for evaluating medical conditions.
Senator Sharon?
Yeah, I suppose as I'm thinking this through, that's true what you're saying. There'd have to be some suggestion to the disciplinary board that there's a improper prescribing practice going on for them to investigate. That makes sense to me. And if I broaden it out to say that would be true for opioid or any other kind of prescribing practice. So I shouldn't be narrowing my thought process down specifically to this. So because it's now a mood-altering substance, obviously, that's being prescribed, but there are multiple mood-altering substances that are prescribed by physicians, and you can probably Dr. Feelgood shop for a number of different kinds of medications. And until we are able to succeed, and I hope we do, at some point in not only tracking what my practices are in terms of drug utilization, but what prescribing practices are, we should use the customary process for overseeing this, which is the Board of Medical, in this case, will be the Board of Medical Practice.
Let me suggest at this point, maybe we hear some testimony, and if some persons have concerns or suggestions on how to handle this issue as well, that would be welcome. Fair enough? Okay. So we're going to go ahead then and start the proponent testimony. And I have a number of people who have signed up ahead of time requesting to speak. Ms. Ozzie, you are on the list. I didn't know if you wanted formally to make any additional presentation as well, or if I should go on. Patrick McClellan is the next person on the list.
You may continue, Mr. Chair.
Thank you, Ms. Ozzie. Patrick McClellan.
When does a half hour?
A half hour begins now.
Thank you very much for hearing my testimony. My name is Patrick McClellan. I have muscular dystrophy. I suffer from severe muscle spasms, peripheral neuropathy, and chronic pain. I lost my career and became totally disabled 3 years ago, and have found that eating or vaporizing cannabis has a remarkable effect on reducing my muscle spasms and pain. I am treated at Gillette Specialty Healthcare. My doctors are aware of my use of cannabis and have told me many other patients are reporting the same result. I currently take 26 pills per day, a mix of muscle relaxants, anti-seizure drugs, neuropathic painkillers, and along with high-dose vitamin therapy. And I also wear braces on both legs to help me walk. One of the most intense and painful symptoms of my disease is severe muscle spasms. During an attack, I am unable to walk, to eat, to use the bathroom, or to even dial 911. One of these attacks once left me trapped in fear of my life, in extreme pain, and unable to call for help for hours. I currently carry alprazolam and quinine in a pill case in my medical alert necklace. These are for sudden attacks and have terrible side effects. The FDA has said that quinine can be fatal using it the way that I do. A single inhalation of cannabis works better than alprazolam and quinine, and my doctor has told me that it is safer than my other medications. I do not believe that law enforcement officials are qualified to make medical decisions for me and have no business standing between my doctor and I. I have no criminal record. I have never even had a traffic ticket in the last 25 years. My wife and I are law-abiding citizens, but the state of Minnesota has made me a criminal solely because I want to treat my suffering. Law enforcement's claim that medical cannabis use is my gateway to heroin is utterly ridiculous. I am forced into criminal activity on the streets of Minnesota in order to find a medication that is readily available in other states. I know that you are compassionate people and will not let this injustice continue. I am 47 years old, and I hopefully have a lot more life to live, and I should be able to do whatever is necessary to improve my quality of life without becoming a criminal in the process. Thank you very much. Are there any questions?
Any questions for Mr. McClellan?
Thank you.
Thank you, sir, for your testimony. Martha Boone Schultz. Oh, and if maybe the staff could give the sign-up sheet to Mr. McClellan as well to make sure that all the testifiers sign in, I'd appreciate it. Thank you.
Good afternoon, Chairman Latz and committee members.
Welcome to the committee.
Hello, my name is Martha Schultz. My older sister Maria would be here to testify today, but she is currently living in Colorado with her 7-year-old daughter, my niece, Greta. They are living there in order to legally access Charlotte's Web, a safe and legal liquid form of medical cannabis. Greta takes this mixed in with her food 3 times a day. This medical cannabis has been such a miracle for Greta, but since it is not legal in the state of Minnesota, their family made the tough decisions to move Greta and Maria to Colorado, while Greta's father, Mark, and 2 older sisters, Emma and Laura, ages 13 and 10, continue to live at home on their family farm in Clinton, Minnesota. Greta started seizing at 5 months of age, was diagnosed with infantile spasms at 7 months, and her condition has further deteriorated into a Lennox-Gastaut syndrome, which is a severe form of epilepsy in which Greta has to endure multiple types of seizures each day and has severe developmental delay. Mark and Maria have done everything possible that they can to help control Greta's epilepsy over the past 7 years. To date, Greta has failed 15 different epilepsy medications, 2 strict specialized diets, and even brain surgery. This past summer, after much research and prayer, Mark, Maria, Emma, and Laura decided that moving part of their family to Colorado was necessary to give Greta the greatest shot at seizure freedom. Greta's longtime epilepsy physician from St. Paul even supported them going to Colorado. He knew that Greta had run out of options to treat her epilepsy. So they went to Colorado, purchased a home there, went through the rigorous process of getting Greta approved for medical cannabis, and were finally able to start Charlotte's Web on November 12, 2013. Since starting the medical cannabis, Greta has enjoyed nearly 80% decrease in her seizure activity, has been able to get off 3 of the pharmaceuticals that she was taking, and most importantly, started doing things like she has never done before, such as being able to hold a spoon and bring it to her mouth. Greta's teachers in Colorado have been so impressed with her progress, they have increased her time in the mainstream classroom each day at school. We are also super excited that she recently started giving kisses again, an ability that her epilepsy and her medications have taken away from her for over 3 years. But now that is back too, thankfully. Such amazing progress is being made with the medical cannabis Greta is taking. So why in the world can't this family be back together and be able to give Greta the medicine she needs while in the comforts of her home with her family around her here in Minnesota? Bringing the cannabis back to Minnesota would risk a federal felony conviction, child endangerment, and a Minnesota state misdemeanor conviction. Maria would also risk losing her master's and bachelor's license in nursing, in addition to possibly losing the access to Charlotte's Web, the only treatment that is currently helping decrease Greta's seizures. This risk is just too great. Greta absolutely adores being with her family, especially her sisters, and this is something she has been able to do only 18 days of the last 170 days. Maria and Greta are not only separated from Mark, Laura, and Emma, but also away from grandparents, aunts and uncles, cousins, and lots of friends back in their community. It would be illegal for her to come back to Minnesota, even if it was just for a short time. This is just not right, and it sure is not fair. The medical cannabis that Greta is taking in Colorado does not and would never give anyone a high because of the extremely low amount of THC that is in the cannabis she takes. It is safer than any of the prescription medications she has been on over in the past 7 years. But they legally cannot bring it back home or even access it in their home state of Minnesota. The best medical treatment that Greta has ever had, and it is illegal in our state. This is so unfair and so wrong. You have all been elected to serve the people of this great state of Minnesota, and you have the power today to help change this law in Minnesota. For our family's sake and for the sake of so many others who are suffering, please, please pass Senate Bill 1641 today and help bring Greta and Maria back home. Thank you for your time and your consideration.
Thank you, Ms. Schultz. Any questions on members of the committee for Ms. Schultz? Senator Hall.
Thank you. Ms. Schultz, Could you tell me, Greta, what type of cannabis does she take?
Charlotte's Web.
Okay.
It is a
Is it oil?
specific strain. It is a liquid form. It is an oil. And they either mix it in with her food 3 times a day, or else they put it in an empty gel capsule that's easier for her to take.
Good, thank you.
Yep.
Any other questions for Ms. Schultz? Would you like to introduce the two people with you?
Sure. This is Emma, Greta's older sister. She is 13. And then this is Laura, who is 10. And so we've got the family pictures here because, unfortunately, Greta is not able to come here and meet you all in person. But so we wanted to certainly put a name with a face today.
Well, thank you, all three of you, for appearing here today.
Thank you.
Christy Pauling. Schultz, please be sure to sign the board as well. Thank you. Ms. Pauling, welcome, and if you'd like to introduce those with you as well.
I will. Good afternoon. My name is Christy Pauling. Along with me is my husband, Jeremy, my daughters, Kaylee, Cassie, and Caitlin. We are here today on behalf of Caitlin. She is 7. She suffers from Batten's disease and intractable epilepsy. Batten's disease is a neurological disease that is caused by genes being odd-shaped and kills off brain cells, and with every seizure, it kills more of her brain cells. She is on 10 prescription drugs, which are in front of me, that have worse side effects than medical cannabis, and they are FDA approved. A few side effects of the medication she is on are liver damage, kidney damage, loss of eyesight. About an hour ago, I gave her Diastat, her emergency medicine, which is Valium, 20 milligrams, to help stop some of the movements. It has done nothing. She'll do this for hours on end. And it's not something that anybody likes to watch. But this is our daily routine. We have no other legal, we feel that medical cannabis would be a much safer option for her. We have no other legal choice right now but to give these medications that are horrible for her. She started out as a healthy child, and when she was 3, she started having seizures. We were told by many specialists she would outgrow it. As the seizures got worse, we sought out other specialists. When she was 5, we finally got the diagnosis of Batten's disease. Not something a parent wants to hear. She has a life expectancy of 10 to 12 years of age. Since diagnosis, she has regressed back to an 18-month-old. She cannot eat except through her G-tube. She cannot walk, she cannot talk, and is wheelchair-bound. We have no way of knowing if she is in pain, she can't tell us, and she constantly has seizures. We are hoping that with the legalization of medical cannabis, it will help with the seizures and maybe get to hear the words Mom and Dad again. She has not said since 4 years old. We also hope for a few more years with her. You would think the hardest thing was the diagnosis, but it's telling her 2 older siblings that her sister is going to die. We have looked for remedies and procedures. Nothing has worked. Then we heard about Charlotte's Web in Colorado. We are torn between uprooting our family and moving to Colorado away from our family and the state we love, or staying here and see what happens. We need this law change now for safe legal access in the state of Minnesota. I'm a registered nurse with a Minnesota state nursing license. My husband is a business owner. If we choose to do the illegal route, I run the possibility of losing my nursing license, going to jail, or the most important thing to me, losing my beautiful daughters. What kind of parents are we if we break the law? What kind of parents are we if we don't do everything we can for a terminally ill child? We have decided that if Minnesota does not pass the bill legalizing medical cannabis, we will go to Colorado and leave the state that let me down and so many others. This would require uprooting everyone and take my daughters away from grandparents, aunts, uncles, cousins, and the family values I thought Minnesota offered. When there is treatment that is working for lots of kids in other states, Minnesota needs to be open-minded and give my child and other families a chance at a better quality of life for their loved ones. Thank you for letting me share my testimony today.
Thank you, Ms. Pauling. Mr. Pauling, would you like to say anything?
No, I'm good.
All right.
He's kind of outnumbered.
All right, any questions by members of the committee? Well, Senator Newman.
Thank you, Mr.
You have
Chairman.
a question, Ms. Pauling. Hold on.
Ms. Paulus, and the form of the marijuana that you provide to your daughter, what is it and how is it administered?
Ms. Pauling.
We have not administered any form of it. It is, like I said, it's illegal here. I can't do this by myself, and if we split our family and half of us go, I can't do it.
The form we would be using would be the Charlotte's Web. The oil form is the main form that we'd be using with our daughter.
Sure. Thank you.
Yep.
That's the information I was looking for. Thank you.
All right, Chris Stubbs.
Good afternoon.
Mr. Stubbs, welcome.
Thank you. My experience comes from, started, I could say, officially in 2001 with my entrance into college and the passage of the constitutional amendment in Colorado with respect to medical cannabis. I hold two bachelor's degrees, one in biology, one in chemistry, and about 13 years of relevant industry experience. So I'm here to answer any questions or offer advice as we move this process forward. As a primer, I think on medical cannabis, one should understand that all of our bodies have what's known as the endocannabinoid system, which is a series of receptors in our neurology, the CB1 receptor, and our periphery, the immune system, the CB2 receptors. The reason, the answer to the question, how can this particular therapy work in so many instances and so many illnesses for so many different people, is because of that very biology that not only humans but all mammals share. So when we talk about epilepsy, for example, this is just a small window into the rather large and powerful efficacy that this plant offers us in many different forms. I would say that the scientific evidence behind this is very great. We have almost 60 years of intellectual property worldwide that contributes to our knowledge of this plant and how it works and how our own biology interacts with that plant. So moving forward, what we have in front of us is a bill that will save you a lot of time and effort. In Colorado, for example, in 2001 to 2009, we had no industry regulation whatsoever. We had an affirmative defense for the patients to be able to possess and grow their own medication, but it was not until very recently that any standards were put in place for safety compliance, as we call it in this bill. And this is a central tenet and a very important part of what we're dealing with here. This is what separates medical cannabis from recreational cannabis. You know, I know that the committees, various interested parties are very concerned about the flower itself, about smoking the flower itself. But I want you to understand that this is overall a very safe method of administration, and whether it's a pill form, an infusion, a topical, we can't possibly know what the content of these products are without potency testing and health and safety testing. So by allowing this, I think you've saved yourselves a lot of time and effort. With cannabidiol specifically, in the instance of seizures, I was an integral part of formulating that therapy. I tested that strain as a flower in the laboratory and was able to report that they did have a plant that had cannabidiol in it. Most of the plants that we have are grown for high THC content, and that's about it. However, there are over 60 identified cannabinoids, all with very small chemical modifications to their structures, and it takes some highly analytical equipment and good technicians to be able to discern what all those constituents in the plant are. However, when we're able to do that and really brand this as medical cannabis with proper labeling and packaging and distribution, then we help, whether it's a pediatric cannabis, pediatric epilepsy patient, or an adult with cancer or any other autoimmune disease. we're able to speak in terms of milligrams per kilogram. The physician's able to gather data and move the process forward. So I think if we're compassionate and if we're driven enough, the things that become important ahead are the rulemaking process, for example. The patients are going to leave or perhaps take the steps necessary in their own lives here in Minnesota to get this therapy. But sadly, as I just mentioned, if the content, for example, with cannabidiol isn't there, then they might not find that relief. So it's up to us to form a mechanism going forward that is a well-profiled medical cannabis enterprise, right? So I think one of the things that we get also worried about is the dosage and the prescribing or the recommendation by physicians. The dosing ranges in these patients from tens of milligrams today to cancer patients that are taking upwards of 1,000 milligrams of delta-9 THC a day. One might be worried about psychoactivity and the recreational high, but truthfully, it's not until some of these elevated levels of cannabinoids are reached that you start seeing curative effects or analgesic effects. And it's not up to us to tell these physicians how to practice medicine. It is up to the patients and the physicians themselves to navigate. I think that one of the problems in Colorado early on were, the rulemaking. So let me back up. In Colorado, the Department of Revenue deals with the licensing and regulation of the business side, and the Department of Health deals with the physician and patient side. And that's a pretty neat breakdown in a lot of different ways, and I know that we don't deal with it that way here. But we started to see physicians that were writing incredible numbers of recommendations. And that struck a red flag with a lot of people. And one of the reasons for that is it's an emerging market. I don't think any of the Mayo Clinic doctors would jump up and start writing these recommendations right off the bat, while others may be more willing to. So there may be some red flags that some of you see in who's writing recommendations and how much dosing there may be and what is required. And there are things that we don't know. But I can tell you that the framework that Senator Dibble's provided here is an excellent one for moving forward. And as compassionate people, it's up to us to learn about the science behind this plant and why it works. It's well established, and we can study it more with the proper mechanisms moving forward. So I hope that I can act as a resource for all of you, and I yield to questions.
Thank you, Mr. Stubbs.
You're welcome.
Any questions from members of the committee for Mr. Stubbs? Senator Newman.
Thank you, Mr. Chairman. Mr. Stubbs, the sheet indicates that you're an expert familiar with Colorado law, and I'm a guy, I don't know very much, if anything, about marijuana. Sure. And so I want to ask you some questions about some things that have happened out in Colorado that I've read about. And I do not mean to be in any way confrontational. I'm simply looking for information.
Indeed. That's okay.
I pulled up an article about a woman who was killed in her home after her husband had ate some pot involving candy. Mm-hmm. There was a marijuana edibles spotlight in Colorado after student's death. Denver man consumes edible pot before killing wife. That may have been the same incident. I'm not sure of.
Sure.
There was something here on regarding safety concerns about legal marijuana edibles. Colorado rejects pot for post-traumatic stress syndrome. Pot and child endangerment bill fails in Colorado. And this is just information that we get in the news. Sure. I don't know if it's accurate or not. My question sort of centers around, most of the time we think in terms of pharmaceuticals and drugs as being regulated by government agencies after having gone through a number of tests and so forth. And so how do we as legislators who do not have the degree of expertise that you have in the chemistry field, how do we know that the kinds of things that I just looked at in the news from Colorado are not going to happen in the medical marijuana field? I don't know if that's a fair question or not, but
I'll attempt it.
Okay.
Stubbs.
So I think that with respect to the adverse events, and this is something, a term used in a lot of clinical trial work, right? But in this case, a woman being killed or somebody jumping off a balcony are very adverse events. Part of this is due to the packaging and labeling and dosing situation, okay? That man was specifically told to eat a sixth of that cookie. Now, that's probably hard for all of us to eat a sixth of a cookie, right? But indeed, the dose was labeled, and the people at the dispensary told him exactly what to do. He ate some of it, didn't feel anything, and ate the rest of it. Now, this is under the recreational side. This is not a gentleman that was prescribed a card. So the medical oversight was lacking there. And I can back up and say that it is up to every physician and up to every patient to make sure they are sound mental capacity before attempting some of these treatments. And that goes for prescription drugs as well, right? There are a lot of adverse reactions in your mental capacity. So why the man jumped off the balcony, I don't know. But patient education, and in that case recreational education, is the key. And he made the choice to eat more. He might have not made the choice consciously to jump, neither the woman being killed either. People make these choices. It's their, we all have a certain level of personal responsibility that should be rather important. So we can take steps as a legislature, as a consultant, as whoever, to try to tackle these things. And I would like to remind you that the rulemaking process itself becomes very important. This is when you can bring industry consultants, experts, stakeholders to the table and really hash out the details of how these processes look. And it's a black box, right, at this point in time. So I would hope that you all take that into consideration. What we're doing here is essentially providing an affirmative defense and providing a mechanism to get some patients registered and create some businesses. But outside of that, there is a whole year of rulemaking and rulemaking that will go on after that to update those rules to take care of these details. You mentioned the PTSD story, and frankly, it's a very disappointing one. One of my concerns with this bill and with all medical cannabis bills is that we tend to want to make a choice or make a decision for everybody else on what we think these people should be using this medication for. Yet, if I tell you that I like St. John's wort or echinacea or any other medical plant, I'm not questioned as to why that might be my lifestyle choice or my choice to use those nutraceuticals. I would say that, if you back up and look at the American Herbal Products Association, which generates guidance and actually regulates their industry on nutraceuticals and other medical plants. Moreover, the World Health Organization has a set of guidances for this. The ISO standards for laboratories have standards on this. So there's existing models of how to use medical plants out there, but it's only with this one that we tend to say, well, if you want to use it for PTSD, I'm not sure if that's necessary or not. Well, we have a fundamental misunderstanding of, again, the biology within us as to why this plant is effective. So PTSD was denied, and yet other states allow it. And I feel like these men and women deserve the best treatment. When you are able to treat your body in this holistic manner, by activating the cannabinoid receptor system in the brain and in your immune system, what ends up happening is you can eat, you can sleep, You can lay with your wife or your husband. You're happy again. And I've seen soldiers cry in these same kind of testimonials because it has saved their lives, just like it will save the lives of the pediatric epilepsy patients, just like it'll save your lives, possibly. And you have to realize that, and I'll step into the theoretical side here a little bit, but our bodies were designed, in a sense, or have evolved to really fight off some nasty stuff. And by that I mean we used to die from tooth infections at 20 years old, 15 years old, right? Our life expectancy used to be a lot different. So we needed a robust immune response to be able to survive. Well, now we don't have those same problems. And it turns out that the endocannabinoid system itself is a regulatory mechanism for our bodies globally between the pro and the anti-inflammatory sides. When you get the flu, you spike a fever and that goes down. You spike it again and it goes down. And that's part of your immune system's way of propagating immune cells to kill the pathogens and create a harsh environment for the pathogens themselves. Well, now that we, are growing older and have these active immune systems, a lot of what we deal with are age-related autoimmune diseases like arthritis and cancer and lupus and MS. Some of them have to do with fundamental breakdowns in genetics. Others have to do with the length of time that we live. But this is not something that it's gone from cancer, pain, and nausea and HIV to actually, in the literature, they're describing clinical endocannabinoid deficiencies. And the fact that this can be a mechanism for longevity by decreasing these inborn errors and inborn problems in our daily life. So,
Mr. Stubbs, I'm going to ask you to wrap up so we can move on to the opponents as well.
I will yield to any other questions, actually, because that was, I think, a couple of pointed ones that you had.
Thank you. Senator Hall, and then we'll move on.
Thank you, Mr. Chair. And Mr. Stubbs, two quick questions. You don't need to go into them long. I just wanted to know, I've been told that marijuana, first off, has not been vetted thoroughly by the FDA. So is that true or not? And secondly, I've been told that research is, there's conflicting research that smoking marijuana may be harmful to the brain development of children. Is that true?
So,
Mr. Stubbs.
Yes, Mr. Chairman. Could you clarify the first question?
Yeah, it was just, has the FDA approved most forms of marijuana yet? I'm told they haven't.
They have not approved.
No.
A whole plant.
Thoroughly vetted them, I guess.
Thoroughly vetted. So there's a major difference between what they have and what they have not done. Marinol, for example, is an FDA-approved substance, but it's a single molecule formulation of delta-9 THC in sesame oil. And that is wholly different from the whole plant extracts that we may formulate these products with. And part of the reason they have so much more efficacy is because there are 60 cannabinoids and a whole class of terpenoids that are all biologically active in various different ways. So the FDA and some of the FDA consultants I've spoken with in the past are very excited to get into this. But there are, of course, you're aware, federal regulations that prohibit us from pursuing that with them unless you go down the investigational new drug path. That's a very expensive endeavor. I've tried that part, and it doesn't go very far when you realize that you're spending literally millions and millions of dollars a year trying to get an ear. So
Mr. Chair,
Senator,
if I may, is this going to open up more research for the FDA?
Not directly.
Okay, not directly.
Not then unless they, pardon me, unless we reschedule it, which was a conversation that we came across yesterday. It would be very wise for the state to consider rescheduling cannabis for that purpose, because you have a tremendous research potential here with the university and the Mayo Clinic, but they're not going to touch it because they require DEA regulations, and the DEA will not touch it because it's outside of their long enforcement chain of custody.
Right, and then, Mr. Chair,
Go ahead.
if the second question, is smoking marijuana harmful for the brain development of children? Can it be?
Mr. Stubbs.
That area of research is very hot, as well as all of medical cannabis research.
Okay.
I will not say that it's harmful. In fact, our own federal government has a patent on the use of cannabis and cannabinoids for neuroprotectants and antioxidants. And in that literature, in that document, they describe cannabidiol, which is the Charlotte's Web-based infusion that I have helped with in the past and will continue, and other cannabinoids, including Delta-9 THC, being neuroprotective and neurogenerative, meaning it can actually foster the growth and development of brain cells. Now, I think there's a fine line between what a physician and a parent and a child do versus what we know from the outside sitting at this table. For example, one of the first concerns that Charlotte Figge brought to my attention before they went down the cannabis path, this is, Paige Figge, Charlotte's mom, I counseled them on the safety and efficacy.
Mr. Stubbs, if you could just focus on the question, if you wouldn't, about the effect of smoking marijuana on children's brain development.
I think I've answered it.
All right.
Thank you.
But I do have a follow-up question for you.
Sure.
Do you have any information on the efficacy of smoking marijuana as opposed to using it in any other form?
Yes.
Oil or marinol or whatever it is.
If I may.
Please.
There are several longitudinal studies that point to the safety profile of cannabis even when being smoked. One of them mentioned specifically that there may be a 13 to 15-ish% decrease in lung capacity during the time someone's actively smoking, but that the cannabinoids present in that smoke and vapor are actually protective in small cell lung carcinomas and other carcinomas of the lung, and that when one ceases smoking, no matter how long they've been doing it, their lung capacity increases and they have clear lungs within 30 to 45 days.
I think my question was more directly toward addressing particular medical conditions.
Sure.
The choice between smoking marijuana as opposed to utilizing it in some other form.
If I may, I think that there's a lot to be said for the two mechanisms. One, smoking and vaporizing provide instantaneous relief for many people. Being that these are anti-inflammatory agents and a lot of pain is inflammation-based pain, and then a lot of the other subsection of pain is neurological pain. You've got cannabinoids that are anti-neurological pain and anti-inflammatory. When you ingest those through the oral administration route, it's fast relief. Now, if I myself suffer from migraines and inflammatory pain, I would much rather eat a formulation to help with this, which I do. However, smoking and vaporizing a bit to increase that plasma level is an immediate reaction, and it's a safe way of doing it. Now, the physician and the patient themselves can make those decisions on the risk factors that they see before them with that specific patient's medical history. But there are definite efficacy with respect to smoking.
Thank you. Any other questions from members of the committee at this time? Mr. Stubbs, thank you very much for your time.
You're very welcome.
I'll let people know, and we have gone past the 30 minutes, and we'll give equal opportunity to the opponents if there are questions from the committee that lead to a longer conversation. I do have Darrell Paulson also, who had signed up requesting to speak. Is Mr. Paulson here?
I'm here.
Okay. Would you like to speak, sir?
Yeah, I just would like to say a couple things.
We're going to ask if you can come over to the table and make a microphone available to you.
My name is Darrell Paulson. I come before this committee today in support of this legislation. Many of you know me as a disability advocate, as a disability rights advocate who works in many areas. I first spoke about this issue 24 years ago. Do I use cannabis? Yes. Does it work for me? Yes. Do I use Marinol when I cannot find cannabis on the street or I cannot get it from the resources that I'm used to? Yes, I do use Marinol. Does it work? Not very well. Do I choose not to use it in the morning or in a day like today as I sit here before you? Yeah, I choose not to use it for a couple reasons. It's not as effective. It makes me very sedated. It makes me almost lethargic at times where I'm not even able to communicate or I'm not even able to hold my head up at times. So do I use it primarily at night or when I don't have cannabis? The answer is yes. How long have I had it? Well, about 8 years. Do I use cannabis in conjunction with my Marinol? The answer is yes. Do I use it in the presence of my minor child, which I have a 2-year-old child? The answer is yes. My daughter doesn't know any different from the medicine I take out of a bottle or from a medicine that I might put in a pipe and choose to light it. All she knows is that that's Daddy's medicine, and she knows when I use it, I'm able to have a quality of life that no other medication gives me. Do I work up here at the Capitol for issues like this, or do I work for the greater good of people with disabilities? The answer is both. So I just really want you to do the right thing today. Pass this through your committee. Make sure the relationships are developed with the doctor and the patients that have spoke to you today, and continue doing your own research as we develop a very tight, close program that we're hoping to do. Will I be able to benefit from the use of a non-smoking form of cannabis? Probably not. Because for me, for the last 20 years of my life, I've used cannabis. And the primary method that I use it is smoking it. When I smoke cannabis, I can return back to work within 5 to 15 minutes. If I take my Marinol, I cannot return back to work for the rest of the day. So I just want you to look at that when we talk about making this available in a non-smokable form. It would eliminate individuals like myself who do benefit from a quality of life from smoking it. Thank you. Any questions?
Thank you, Mr. Paulson. Any questions for Mr. Paulson? All right. Thank you very much, sir.
Thank you.
All right. Was there anyone else who wanted to add to the conversation as a proponent before we wrap up this portion of the testimony? I see a hand in the far back. Sure. Come on forward, sir. Just, I'm going to ask you to be brief, but I do wish to give you an opportunity.
Thank you, Mr. Chairman.
Go ahead and state your name for the record, if you would.
Aníbal Fernandez. I'm a retired police officer. I just front of you to tell you that as a retired police officer responding to many crime out there, I need medical marijuana. I've been dealing with a lot of post-traumatic syndrome, a lot of criminal behavior, and I've been helping me a lot. I believe the patient has right, and police officer also become to be patient. Thank you very much.
Thank you, sir. Any questions, Mr. Fernandez? Thank you very much. All right. We will move on to the opponents. The first person on my testimony list is Commissioner Doman. Welcome, Commissioner.
Thank you, Mr. Chair. Good afternoon. For the record, my name is Mona Doman. I'm the Commissioner of Public Safety, and I appreciate the time that you're allowing for me to offer some thoughts today. I'd like to begin first by saying very clearly that I know firsthand and I fully understand how difficult it can be to watch a loved one, a family member, suffer with a major illness or a chronic condition. And truly, my heart goes out to anyone faced with those tough circumstances. I appreciate the fact that family members work tirelessly to find effective treatments. At the same time, as the Commissioner of Public Safety, my mission and that of the work that we do in our agency is to protect the safety of all Minnesotans. I also understand the difficult decisions that you as policymakers face as you work through these complex issues in order to set policy and law for our state. My hope is that you will move with caution as you consider the question of legalizing medical marijuana. Marijuana is arguably one of the most widely abused controlled substances in Minnesota. It is a Schedule I controlled substance under federal and state law, meaning that it has a high potential for abuse and a lack of accepted medical use. Marijuana is not a single drug or an active ingredient. It is a complex substance, and it is reported to be far more powerful today than it was 20 to 30 years ago when I entered my law enforcement career. Additionally, I believe that it can serve as the gateway to other risky behaviors and to the use of other illegal drugs. I fear that legalizing marijuana for medical purpose will lead to the perception that it is harmless, which will result in increased abuse illegally by people, including our youth. A marijuana grow operation anywhere, even if lawful, creates a valuable cash crop that in turn creates a significant risk of drug robberies and other related crimes. The high monetary street value of marijuana provides monetary incentives for criminals, gangs, and organized crime. People in our state are victims of property crimes, assaults, child neglect and endangerment, robberies, and homicides that are related to illegal drug activity, including marijuana. In some cases, the incidents are directly related, such as if someone impaired by marijuana causes a motor vehicle crash, which kills or injures innocent persons. In other cases, the impact of marijuana abuse is less apparent, such as the high percentage of, say, meth or heroin or cocaine users who began their illegal drug experiences with marijuana. We believe that marijuana is a dangerous substance which has significant detrimental effects to public safety. Given the knowledge of potential social risks associated with marijuana, I believe that we here in Minnesota should wait for additional scientific research and watch for evidence coming out of states that have legalized medical marijuana before moving forward to legalize it here. I hope that we can take the time to wait and learn more from the good and the bad experiences in other states. Our main focus at the Department of Public Safety is to keep the people of Minnesota safe. And we urge all of you to weigh the information and evidence that is available regarding public safety before legalizing the use of marijuana for medical purposes. Thank you.
Thank you, Commissioner. Any questions for Commissioner Senator Hall?
Thank you, Mr. Chair, and Commissioner. Good to see you. I have a question. I know you've been here for the discussion earlier. Do you see any potential problems with the beginning stages of this program when people are, still getting prescription, or they haven't got their card, or the dispensary centers are not there? Do you see any public safety or problems with that?
Mr. Chair,
Commissioner.
Senator Hall and members, I was trying to think through that as you were having that discussion, and I think there are some concerns. I understand fully the intent to carve out the group of people who Senator Dibble is trying to address in this bill, and so I appreciate that. But I'm thinking from a law enforcement perspective, the impact to a law enforcement officer on the street, on a traffic stop, receiving a complaint, and the complexity of working through that process where someone might potentially be purchasing it illegally, if you will, during that transition process. And I would have concerns about that.
Any other questions for Commissioner Doman? Thank you very much, Commissioner.
Thank you, Mr. Chair and members.
Dennis Flaherty. And Jim Franklin.
Mr. Chair,
Mr. Flaherty.
I do have a handout here that we would like to pass out if you'd be kind enough to help us. For the record, my name is Dennis Flaherty, and I'm Executive Director of the Minnesota Police and Peace Officers Association. And as an organization representing about 8,500 rank-and-file police officers across Minnesota, we have strongly opposed legislative efforts to legalize marijuana for medical purposes. Fundamentally, we simply do not view marijuana as some harmless substance, but instead see it as an addictive drug, as well as a gateway drug for far too many, leading to serious drug abuse and addiction. Not to mention, as Commissioner stated, it continues to be a Schedule I controlled substance under federal law. Studies conducted by the National Survey on Drug Use and Health show that for adults who use it on a regular basis, 1 out of 10 become addicted, and even worse, 1 out of 6 teens. While very concerned about the adult addiction rate, we're deeply concerned for the effects of marijuana on children. The adolescent brain is especially susceptible to marijuana use. Marijuana use has significant effects on IQ and learning, and studies have showed that persistent use among adolescents can reduce the IQ 6 to 8 points. In Minnesota, marijuana is by far the most used legal drug among adults, with almost 7% reporting use at some time during the last year. Any other illegal drug besides marijuana was used by less than 1%. For youth, it is also the most used illegal drug, with 1 in 3 12th graders and 1 in 6 9th graders reported having used it in the last year. This information was obtained through the Minnesota Health Department. Marijuana today is simply not the marijuana of the 60s and 70s. Over the past 20 years, its potency has tripled, and it has grown 5 times stronger with higher levels of the psychoactive ingredient THC. Studies conducted by the University of Mississippi's Potency Monitoring Program have found that average potency has jumped from 3.4% THC in 1993 to 12.3 in 2012. Scientists at their lab have seen strains of marijuana as high as 36%. Important here is that back in the 70s and 80s, the THC levels averaged 3%. According to information received from SAM, Smart Approaches to Marijuana, in the states that have gone the medical marijuana route, the profile of the average patient is a 32-year-old white male, history of alcohol and substance abuse, no history of life-threatening illness, 87.9% had tried marijuana before age 19, 75% of the Caucasian patients had used cocaine, and 50% had used methamphetamine. Again, looking at medical marijuana states, Colorado before they went to full legalization, Oregon and Montana, the vast majority of the patients reported to be using it to treat chronic or severe pain. In Colorado, 96%, in Oregon, 91%, and in Montana, 93%. States with medical marijuana have abuse dependency rates almost twice as high as states with no such laws. Increased use of marijuana can lead to increased drugged driving. Sources say that those smoking marijuana are more than twice as likely as other drivers to be involved in motor vehicle crashes. It is my members that see all the problems associated with marijuana abuse and feel very strongly that as a state, we cannot afford to go this route. They are very clear and certain in their opposition to what is contained in this proposal. Interesting to them was the strongly worded resolution from the National Association of Drug Court Professionals, who in December of 2012 opposed the legalization of marijuana for any purpose, including medicinal. They stated, and I quote right off their webpage, quote, "Drug courts serve seriously addicted individuals with long criminal records, and in every case, they tell us it began with marijuana," quote. My members are encouraged by studies that find that certain properties of the marijuana plant may have ingredients helpful to sick people. They feel that is the future, and that is the way we should proceed. They see no future for Minnesota in smoking marijuana. At a recent legislative conference, our members spoke clearly about their desire to ease the suffering of children and others, and were energized by the thought of Minnesota leading the way on clinical trials approved by the FDA. They were most appreciative of Governor Dayton leading the conversation to jumpstart these studies and trials through the Mayo Clinic. Again, we see no future for Minnesota in this bill. We see no future for the sick children from crude marijuana. We urge you, with the limited time left, to find another solution. This bill to us is not the solution. Thank you.
Thank you, Mr. Flaherty. Would you gentlemen like to go through the testimony and then open it up for questions? Sure. Okay. Mr. Franklin, go ahead.
Mr. Chairman, members of the committee, for the record, my name is Jim Franklin. I'm the Executive Director for the Minnesota Sheriff's Association. Today, let me try to address, rather than duplicative, let me try to address the concerns that we would have from implementation of this, from the fiscal aspects on cities, counties, etc., as we implement this law. Let me take a moment and go off script. My partners next to me get very nervous when I do that. Well, let me just say this. Some of us in the law enforcement community have experienced children with seizures. Some of us in the law enforcement community have had family members, children, parents, brothers and sisters with cancer and all other kind of debilitating diseases. Some of us in the law enforcement community have held the hands of the children and the wife whose husband just committed suicide because of drug addiction and marijuana. Some of us have delivered those troubling messages in the middle of the night, knowing the causation factors related to marijuana and other drug and alcohol-related symptoms. One of the things that we law enforcement have been characterized as non-caring, I think we are very caring. We are concerned, and that is one of the reasons why we have suggested alternatives. We have looked at trials. We have recommended Mayo. We have looked at the University of Minnesota. Some of us have contacted and been in D.C. speaking to the administrator, the regional legal directors. Some of us have helped the governor's office and the Commissioner of Health maintain contacts directly with DEA on how to expedite this, especially for children in Minnesota. Be clear, we are very concerned and want to do what we can to address those particular issues. They are dear to us. Having said that, let me go back on to some of the concerns that we have. Number one, in the bill, there is nothing in there that helps us in law enforcement training. This is a huge training issue. There's not funding. This is a complicated subject. And we have a huge 10,000 plus people to train and get it right. And it's an issue that we see as a cost to local units of government to try to do this. Number two, some of the things that have not been talked about. You did touch on them a little bit today. But if I take a look at some of the things, and we will all have disputes over articles in papers as being relevant or not relevant. But in Washington, they are dealing with the issue of apartments, housing, lawsuits, police calls about what happens in apartments, smoking, people that are allergic to smoke and other kinds of things. That causes police calls, that causes lawsuits, that causes work for us. We have to respond to those kinds of things. The DWI issues, and I'll only touch on those very, very quickly. There is evidence, and one part of this that was a bit surprising to me is that marijuana is within itself maybe not as dangerous driving as alcohol. But when you mix the two, statistically speaking, we have a major problem. And as we go back and look at our studies over varying things, one of the studies was 23,000 drivers and crashes between 99 and 2010. What we see is a whopping increase in death-related alcohol and marijuana from 16% to 28%. Other studies go even higher. The British studies that are done actually reduce or increase those at a full 50%. All of the DWI laws and things we have in this state are going to have to be reconsidered. We're going to have to adjust our law enforcement procedures. We are going to have to send more cases to the BCA court or the lab. They cannot keep up to what we give them now, and we're going to be having more cases sitting in court, backed up longer, with a multitude of other kinds of problems that we've got to deal with. EMS runs. Statistically speaking, again, as we look at what's gone around the country, as we look at the increase in the number of kids who have touched or been involved with medical marijuana and or stealing it from their parents, the prescription issues that we currently have are appalling. This will, again, amplify those kinds of things. Our fear is that we're going to see more medical runs, more admissions, which simply gets us to the fact of more law enforcement work that we are going to have to be doing in our communities. Additionally, as we look through some of these other kinds of concerns that we have, I want to get to an issue that I want to share with you. The emergency rates in 1991 was at 16,251. By 2008, they were 374,000. A huge increase, again, related back to many of those. Over 50% of those were marijuana related. Additionally, you can argue over the facts that 1 in 6 teens become addicted, but I just want to share with you one of the things that I learned that was troubling. For the admissions of the kids into emergency room situations, 5 years of age and under, there was a 200% increase from the year 2006 to 2012, a 60% increase from 6 to 12-year-olds, and a 92% increase for those from 13 to 14. I'll give you an example of this case that came out of our Alexandria, Minnesota on April 14th. This is a sucker that is laced with marijuana that is in the state of Minnesota currently. Obviously, we don't know, or at least the holder of the sucker would not share with us where the content had come from. But I think this is an example of what could be coming in and what we are going to be dealing with in terms of admissions into our emergency facilities. If we take a look at our jails, our latest statistics from the White House Drug Policy 2011, 52% of those adult males that are booked into jails had prior arrest for marijuana and drugs. Secondly, of the violent offenders, 53% of those had used marijuana, and of the age group, in under 21, 82% of those had been using marijuana prior to their arrest. As we talk about arrests in jail, one of the concerns that we have as we're holding people in jail, how will the medical aspects of this drug be involved as we have to implement patient care in the jail? Now, in the bill, it says we don't have to use it in correctional facilities. However, we've got federal regulations and other issues that we are concerned about with regards to negligent care standards, of which we can be sued for because we're not following medical guidance. Those are concerns that we don't have answers for. Those are issues that we think are out there that we need to look at and study. We agree, and I agree with many of the people who have testified here about studies. We think a clinical analysis and study would be a good thing to move forward with. I thank you this afternoon for some of the things you've already done, Senator Dibble, to tighten up some of the concerns. I won't highlight those. You've already addressed several of those. But the bottom line is we have additional concerns. Be aware this is a tax increase to the local units of government coming down the pike for what we are going to have to do to implement this law. Thank you.
Mr. Skoogman.
Mr. Chair, members of the committee, for the record, my name is Andy Skoogman. I am the Executive Director of the Minnesota Chiefs of Police Association. I'm here today as part of the Law Enforcement Coalition and representing about 350 chiefs of police in communities large and small all across the state of Minnesota. I'll begin by saying that I'm brand new to this position. I took the job within the past month, but I've spent a great deal of time over the last 4 weeks meeting with chiefs and talking about this very issue. It is extremely important to them. They firmly believe that what is decided here in St. Paul will have a direct impact on their department's abilities to keep their communities safe. Their input and their expertise serves as the basis for my testimony, and please know that they all very much appreciate the fact that you're willing to listen to both their concerns and their solutions. As other members of the Law Enforcement Coalition and the Commissioner of Public Safety have already stated, marijuana is a problem already here in Minnesota, and we collectively are not supportive of any bill that compounds this problem. My members know from experience and from their law enforcement peers in other states that any legislation that allows people to grow, possess, transport, and smoke marijuana in plant form will result in the drug being more available to all segments of society. My members work very hard every day to develop policies and procedures to prevent crime and protect victims. Bills that allow for smoking and growing of marijuana will increase crime rates and the number of crime victims across the state of Minnesota.
Just a moment, please.
With that said, we want to make it clear today that we want to be part of the solution to help children and adults who are suffering, who find comfort and relief from marijuana. We are not opposed to a responsible and reasonable first step toward finding common ground on this issue. We are very encouraged by Governor Dayton and legislators who believe a study and a clinical trial should take place before Minnesota approves a comprehensive medical marijuana statute. A study and clinical trial at a reputable Minnesota-based clinic has the potential to bring patients the relief they need with the safeguards that we feel are so very important in this issue. Even the executive director of the Colorado Department of Public Health and Environment said recently that more data is needed. He said, and I'm quoting, "We still don't know if this works. We hear about cases anecdotally where this is effective, but nobody covers the cases that are ineffective. We need to do more research," end quote. Law enforcement feels we have both an opportunity and a responsibility to be at the forefront when it comes to researching medical marijuana. In addition to our support of research, we brought a proposal to the table to allow CBD to be extracted and delivered much like a regular prescription drug. Again, no smoking and no growing of marijuana. So far, however, this idea has been rejected. In the end, we believe research, along with legislation that controls the drug's usage, dosage, and delivery method, are the responsible and reasonable first steps. This approach prevents the unintended public safety consequences of medical marijuana, while children, families, and adults looking for relief can still receive the benefits. Thank you.
Thank you, Mr. Scoopman. Mr. Kingery.
Mr. Chairman, members of the committee, my name is John Kingery, speaking on behalf of the Minnesota County Attorneys Association. I want to start out by saying that in all sincerity, I respect the authors bringing this legislation forward. I know they are very sincere about the goals of the legislation to address what is obviously a very emotionally charged issue. Also, I want to say that as a parent of 2 children, I can only imagine the agony and frustration that the parents here today are facing. A 2012 survey conducted by the University of Minnesota stated that 34% of 12th graders in medical marijuana states say that they get one of their sources for marijuana is from a medical marijuana prescription. That's one of the messages I want to leave with you today, is the diversion of medical marijuana. The results of that survey prompted the director of the Office of Drug Policy to suggest that regulation schemes are not succeeding in preventing the diversion of marijuana into the hands of young people. Another study indicated that close to 25% of teens who admit driving under the influence of alcohol or drugs believe, of that number, 75% do not believe that smoking marijuana adversely affects their ability to drive. In a national survey on drug use and health and the NCSL in 2010-2011, 21 of the top 23 states in which 12 to 17-year-old teenagers admit using marijuana in the past 30 days are from medical marijuana states. One, as Mr. Flaherty suggested earlier, there is a high correlation between young people smoking marijuana and addiction, and the loss of IQ at a later date. And I would strongly suggest that is due to the significantly more potent marijuana than we had 30 years ago. My message to you today is it will be diverted in the way the bill is currently drafted. It will end up in the hands of our children. I would encourage you to ask your kids. I have. It will result in more kids being arrested and adjudicated for the possession and use of marijuana, and we all know the impact of those collateral consequences. We believe that it sends the unintended message to our youth that marijuana is a safe substance. The goal of this legislation is to find a medical remedy for specific conditions faced by some persons. Our recommendation is to submit marijuana to a rigorous clinical study for a limited number of conditions before adopting a comprehensive medical marijuana statute. Such a limited clinical study would help all of us understand the potential risks and benefits of marijuana while keeping it out of the hands of our children. And I just want to conclude by saying I remember the debate back, I believe it was in 2009, in which you saw the law enforcement folks before you today just simply opposing the legislation. I think we have moved off that position and that message to support and endorse limited clinical studies of medical marijuana, and I think that is a change in our position that doesn't get recognized often enough. And with that, Mr. Chair, members of the committee, thank you very much.
Thank you. I have a question for either one of you that wants to respond to this. How much of your concern is related to the smokable form of use of cannabis?
Well, Mr. Chair, I'll take a stab at that. I think a lot of our concern centers around the smoking of marijuana and the 50-some dispensaries. I think that's one of the common threads that we have in our opposition, is the crude form of marijuana versus the derivatives.
So Mr. Flaherty, you're referring to the crude form as the plants, the stuff that someone would buy on the street currently, that they would either smoke with a water pipe or some other kind of device or in a joint. That's the kind of use that you're most concerned about as sort of leading to these other consequences that you've been describing?
Yes, Mr. Chairman. That and the 2.5 ounces.
And if the use were limited to cannabis in the form of oil or non-smokable form, would you be much more comfortable with the broader scope of the bill moving forward or not?
We, Mr. Chair, we have had conversations earlier in the session about that, and we think that an FDA-approved clinical trial where patients could actually receive it in the forms you're talking about, be it pill, be it oil, that's the route that we should go. I think that would accomplish a lot of what we heard here today, and so we have suggested that, but up to this point, we haven't received much support.
Okay, but Mr. Flaherty, what if it weren't in the form of a clinically approved trial, but it were made available in non-smokable forms through the dispensaries?
Oh, Mr. Chair, I don't know where they'd get the product from.
Okay. Anyone else wish to address my question, Mr. Franklin?
Mr. Chairman, I think one of the issues here is what is the THC level that we're going to be talking about. Again, it's already been said, this is something between the patient and the doctor. The question is, what other types of medications, what other types of things are going on in my body? Mr. Stubbs addressed some of that. What other kinds of, do I have other psychological issues that need to be worked with? And again, without having a clinical analysis and being treated in some way, shape, or form to appropriately address those things, we're concerned about smoking or a one-size-fits-all. We don't know what the THC level is. Obviously, in the children case, CDB is the answer with a limited or no THC. These are complicated questions, again, that research and we would hope doctors would be able to address in a clinical type setting.
Mr. Kingery?
Mr. Chairman, members of the committee, and I have a question too I'd like to ask of the committee as well. I believe that one of the reasons we stress clinical studies is to do a longitudinal study in terms of the impact. Is this helping these individuals? Obviously, there's anecdotal information. We know that. But I think you need a broader scope of a study involving more individuals and over a longer period of time. And if I could ask one question of the committee, Mr. Chairman.
Yes, sir, Mr. You may get 8 different answers, but go ahead.
I've often been confused, I've been told I'm confused, and I am confused on the sequencing here in the bill. It's my understanding that it would be effective July 1st, 2014. And at some subsequent point, and after that date, individuals could get a prescription from their physician. And at some subsequent date, I believe it was maybe a year later, possibly earlier, cards would be available. And at some other subsequent date, alternative treatment centers would be available. Is that an accurate description of the sequencing of the timing here, Mr. Chairman?
I think Mr. King, we will ask the author of the bill to answer your question. Senator Dibble.
Thank you, Mr. Chair. The short answer is yes. The reason the bill goes into effect July 1st of this year is so that the Commissioner can start immediately on the process of doing study, analysis, input, et cetera, rule writing for the purpose of setting up a process by which alternative treatment centers can be established, the security and safety facilities, the process by which folks can apply for registry cards, all of those sorts of things. That needs to start happening immediately. And then we do have a date certain by which the cards need to be issued. You'll find that on page 21, July 1st, 2015. And then, I think the facilities themselves can be opened, just as soon as we can get through the process of establishing all the protocols, all the approvals, et cetera.
Mr. Kingery?
Yeah, Mr. Chairman, members of the committee, and Senator Dibble, I asked my question in all sincerity, and it was not a setup. I think the concern, and I'll ask the gentleman to my left can respond, is after this July 1st, they're legally going to have a prescription for their physician. They can legally have 2.5 ounces of marijuana on their possession. I think our concern, and I'm going to have to defer to the folks to my left, is they're going to buy it on the street, and I think that is going to cause some significant concern from law enforcement.
Of course, a lot of them are buying it on the street now anyway, but that's the... as you've told us.
Yeah. Well, Mr. Chair, that was
Senator Dibble.
Mr. Chair, that was the point. That was the point I was going to make. At least, in the interim, they will have established. I mean, that's not desirable, and we don't want that, and that's happening, and that's what we're trying to address in this bill. People are doing that today. They're participating in a criminal enterprise, and they don't want to be. They don't know the content of what they're getting, what its purity is, whether or not it's got amendments or poisons or anything that's a part of it. It is the Wild West right now for folks, and that's the circumstance. Or they're going without, or they're being forced to move to Colorado or something like that. At least they're working with a doctor and creating and at least undergoing some care and figuring out a path forward. It's better than today.
Senator Limmer.
Thank you, Mr. Chair. The law enforcement, if I could get an opinion from law enforcement, when one is buying marijuana on the street, what kind of potential danger does the customer have in trying to locate and then purchase marijuana on the street? They're going to someone that they don't know. There's, since I don't go out and buy marijuana on the street, I would like to know what kind of potential danger of waiting over a year, as if we did make this legal, what kind of danger to the individual is there if we didn't have the cards or the dispensaries established already? It seems a little backward to me.
Mr. Chair, Senator Limmer, it's fraught with problems because, first of all, the buyer has no idea what they're buying. They have no idea where the marijuana came from, what the levels are, was there pesticides used. They subject themselves to drug ripoffs where the seller doesn't give them the dope and robs them of that money plus whatever else they have on them. So there are a lot of problems, and this happens on a regular basis throughout Minnesota.
Senator Newman.
Thank you, Mr. Chairman. One of the questions or topics we have not discussed yet this afternoon would be that of folk coming into the state of Minnesota from outside of the state of Minnesota. And the bill does touch on that topic in two different places. And I'd like to hear from law enforcement and from Mr. Kingery from a prosecution standpoint, and the author if he wishes to respond. But on page 3, we have got a definition of someone coming into the state of Minnesota that would be allowed to possess marijuana, and I believe it's strictly possession, and that's subdivision 18. And if we skip over to page 15, there is some language in there that says this visitor coming into the state of Minnesota shall not be subject to arrest or prosecution or a penalty if the visiting person doesn't have more than 2.5 ounces of cannabis, and I'm on subdivision 3, beginning on page 15, line 7, beginning there. If he doesn't have more than 2.5 ounces of cannabis and produces, and this is curious, produces a statement from a person who is licensed with the authority to prescribe drugs to humans in the state of the person's residence. And that strikes me as being somewhat of an odd qualifier. So my question to law enforcement, in terms of folks coming into the state of Minnesota, you know, this bill, we are trying to provide relief for Minnesota citizens, yet this bill addresses folks coming into Minnesota with cannabis, 2.5 ounces, in a letter or something from the person who's qualified in the state of their residence. What kind of problems does this visitor from outside of the state of Minnesota pose for purposes of law enforcement, who is prohibited from arresting them? And what kind of problems does it pose for purposes of prosecution should law enforcement deem an arrest as appropriate?
Mr. Chairman. Mr. Franklin. I'll try to take a stab at that. I addressed part of that. This is a training issue. Understanding this bill and implementing it is a training issue. With 10,000 cops to get everybody on the same page is an issue. Secondly, you're absolutely right. This is a concern. We're not going to know from the other state what that other state regulations are. One of the commonalities that we do right now is we share driver's license information. Now, I hate to bring that word up, but we share driver's license information from one state to another so that we can check those kinds of things. There is no database for anything like this. We don't know what the laws are going to be for Colorado or another state. So again, we're going to be rather in the blind. This is a problem. And from a prosecution point of view, I'm not even sure what kind of information I can gather as a law enforcement officer to give to my prosecutor to even implement a prosecution. So I think we're back to clarification, full understanding, full training and vetting to understand that, and then access to all this other data from 20 other states that have medical marijuana laws. So this is a problem. Thank you.
And if I could just add, Mr. Chairman, I mean, we wouldn't know what one document from the other looks like, and they could present law enforcement just about anything, and we wouldn't know whether it's authentic or not. So in reality, it's pretty much unenforceable.
Mr. Kingery.
Mr. Chairman, I guess a suggested amendment at some point along the way. In terms of the definition of visiting qualifying patient, that patient has to be diagnosed with a debilitating medical condition. They could be coming from a state that has a whole different set of definitions and would not match up with Minnesota's definition of debilitating medical condition. And somehow that has to be sequenced, and I don't have the suggested answer, but I think they could come with a legitimate card and possess a legitimate amount of marijuana, but their definitions in that state might not match up with ours. I offer that as a suggestion.
Thank you, Mr. Kingery. Any other questions? Senator Goodwin.
Thank you, Mr. Chair. I've got this article that was just sent out to us, and it talks about states like Rhode Island, Vermont, Maine, New Mexico, Washington, Illinois, New Hampshire, where they have medical marijuana available, some up to have had it available for up to 12 years, and how law enforcement, who originally in some of those states opposed this, have admitted that they have no more crime, no more problems than they had before. So I don't know if you've seen this article, but they're supporting it now in those states. The law enforcement is supporting it in those states where they have medical marijuana. So I guess I'd like somebody's response to that. Have you looked at that?
Mr. Chairman, Mr. Franklin. Senator, I'll try to respond. I do not know what you're referring to, and I have not seen that particular document. I will just tell you that there are documents and things that are produced that counter documents. If you talk to others in the field in some of those states, they would counter some of that. Again, statistics can be put a lot of different ways, and I'm not sure there's a lot of agreement. I do think the states that have had it for a period of time have worked on a number of things. And again, they have differing degrees of problems as we talk to our colleagues around the country.
And then follow up
Senator
on
Goodwin.
a couple other things I heard. One of the things that you talked about is, the potential for automobile accidents. I'm just thinking, on so many different things, even over-the-counter drugs, cold pills, and so forth, that advises you to not use motorized vehicles while you're taking those things. Some sedatives, some antidepressants. I've seen a number of drugs and prescription drugs and over-the-counter drugs that say not to do that. So I know if there's people smoking marijuana illegally now, there are a lot of them, they're out there driving now. So how could this controlled environment make it any worse than it already is? I don't understand that.
Well,
Mr. Franklin.
Mr. Chairman, Representative, I'm not sure we know how it can get any worse. We do know that it's a problem now. We also know that enforcement is not the total key. I mean, it's engineering, how we put stuff together. It's education. And enforcement is sort of the last thing that we should be doing in how we put bills together, how we educate people on that need. And then law enforcement comes in with enforcement. That should be the last thing to do. I really think that, to your question, I think one of our concerns will be, again, how many possible prescriptions are going to be written, how many diseases or conditions are we trying to put in this. We think that, again, there are certain things, certainly the CDB and the issues with regards to the seizures. We think that's something that clinically should be moved forward. But there are other issues that, frankly, I think we're concerned. We just don't know how big the problem is going to be and what it will grow. Statistically, however, we have evidence that the mixing of these drugs and marijuana, alcohol, causes more problems. And they're, statistically speaking, in accidents and other kinds of things, that is being validated, even in the states that have medical marijuana.
And finally, Mr. Chair, one more.
Okay, and then we're about 45 minutes into this side as well, so we'll wrap up.
Okay, and I'm sure that's true, the mixing of, I'm sorry, thanks, Mr. Chair. The mixing of all kinds of medications can be very dangerous for driving. The final thing, I guess, is that the point you made, I think, Mr. Franklin, about children, or maybe it was Mr. Flaherty, children and seizures. I mean, in children having poor brain reactions or brain issues because of marijuana. I don't know of any research that shows that at all, but we certainly heard testimony here today that the constant seizures of some of these children are causing, definitely known to be causing, brain damage. So how would you respond to that, I guess?
Well, Mr. Chair and Senator Goodwin, I think I was the person that discussed it, and what I simply said is that the adolescent brain is very susceptible to marijuana, and studies have shown that when these kids when they smoke marijuana on a regular basis, studies have shown that it does have a negative impact on their IQ, and studies have shown that some 6 to 8 points reduction in their IQ.
Mr. Chair, just one final question for Mr. Flaherty. Mr. Flaherty, can you tell me what study that is? Because I've been looking at studies and I haven't seen that. And that, of course, is not the medical marijuana you're talking about. That is illegal use of marijuana and probably constant use of marijuana that would be creating, and I don't doubt that, constant use of any kind of drug or chemical for adolescent brain is likely to be damaging. But I'm thinking that article, from what I've seen, that research was done on adolescents that use illegal marijuana?
Well, Mr. Chair and Senator, I will get the research to you, number one, and number two, it makes no distinction whether the marijuana is legal or illegal. What it says is that young adults, teens, adolescents that are using marijuana on a regular basis. To me, regular basis means every day. It might mean something else, but regular users are very susceptible. That's simply what I testified to.
Thank you.
All right. Thank you all. Was there, I should call the room, see if there's anyone else who wants specifically to testify in opposition to it, in addition to what we've already heard. Not seeing any, we'll move on then to the portion of the hearing with the committee to discuss and consider proposals before us. Senator Dibble, how would you like to proceed?
Well, Mr. Chair, I just want to thank law enforcement for coming forward and expressing their views. I also compliment them on the sincerity of their perspective and don't doubt that they have true and authentic, sincerely held views and concerns. I do believe that some of their statements were a little bit inaccurate, and Mr. Chair, I just need to call your attention to a couple of handouts that we had put in your packets ahead of time. One is a study that was just issued last week, or finalized and published last week, and that's the impact of state medical marijuana legislation on adolescent marijuana use. And it simply says the conclusion, the study did not find increases in adolescent marijuana use related to legalization of medical marijuana. So even though they may cite some states where there's higher uses of marijuana among young people, where there's legal access for medical purposes, correlation does not equal causation. And I think that's what this finding shows. Additionally, I just need to say for the record, Mr. Chair, because it's troubling, there was a commentary submitted by the members who testified about how this group of folks are working with me closely and made representations to that effect at the table here. And I can just say, and I can show you the emails in which, sure, they've agreed to talk, but they've asked me just simply to leave my legislation at home because there's nothing in the bill that they would support, effectively telling me, take our idea or nothing. They characterize my approach as all or nothing. That hasn't been true. I've issued many invitations to productive conversations. And those have been declined from my perspective. So it just needs, the public record needs to be corrected, particularly when something is published in the newspaper about how a group of people is working with me when, in fact, I don't think they actually are. And in terms of the study and the like, there's never been an actual offer made to me. There have been offers articulated in the press and third hand and that sort of thing. But I've never actually had a productive conversation about, some sort of a trial, which may or may not take years and years to put together, and we don't know who would be able to participate. So I just need to say that for the record. Some of the you're going to get a copy of a study that talks about the effect on the teenage brain, because this Dunedin study was cited and has since been reviewed and shown to have pretty dramatic flaws in methodology. The analysis and the facts and what's been analyzed from a scientific perspective do need to be put on the table. So I just wanted to respond to a few points, Mr. Chair. And then I'll just say that you also have a handout that talks about crime rates and the effect of dispensaries, alternative treatment centers on crime rates, and it's shown not to have a dramatic or any effect. So again, I don't doubt the sincerity of the concerns, but I think we need to look at the experience of states that are doing this well.
Thank you. Senator Dibble, I neglected to take testimony on the fiscal aspect of the bill, and I think we ought to do that before we go any further so that we complete that public presentation as well. So if you don't mind, I'm going to ask if Commissioner Dolman and Wade Setter will both come forward. And members, the preliminary fiscal note has been distributed to each of you. It's preliminary. It's not been finalized yet, but it gives us a pretty good idea of what to anticipate. Let's get over that. Yeah, and before, as testifiers are coming, I'm going to ask our fiscal analyst for this committee, Chris Turner, to speak to that fiscal note.
Mr. Chairman, members, first of all, I have a caveat. It's not Senate practice to make public use of a preliminary fiscal note, but because of the time constraints, we've requested and received permission from MMB to do so. They said that there's some refinements to the revenue calculation on the note before it's complete, but the sections that concern this committee are complete and signed off on. First thing I'd like to point out are the following state agencies that do not report costs, and they were asked directly, and they are the Department of Corrections, the Board of Public Defense, the District Courts, and the Department of Human Services. And that, in other words, direct criminal justice costs of the bill at the state level are considered minimal, with the exception of the Department of Public Safety and the BCA. The fiscal note did not address the local and indirect costs, but I think that Mr. Franklin did a pretty good job of summarizing those. So then I'll move on to the three state agencies that do report costs: the Department of Health, Court of Appeals, and the Bureau of Criminal Apprehension within the Department of Public Safety. The Department of Health is not under this committee's jurisdiction, but I'd just like to point out it bears the lion's share of the costs for the regulation and licensure in the bill, and those costs are paid for with license fees. The bill deposits those fees in the state government special revenue fund from which the health department activities are funded. There are no general fund costs or revenues associated with the Department of Health in this bill. The two agencies that are under the jurisdiction of this committee that report costs are, like I said, the Court of Appeals and the Department of Public Safety. The Court of Appeals estimate. I'm sorry. Go ahead. The Court of Appeals estimate is on page 17 of the note. Court administration estimates 43 appeals of denials of permits or ID cards by the Commissioner of Health in 2015, and 5 appeals annually in subsequent years. The court valued each appeal at $6,700, and this comes to $288,000 in fiscal year 15, $34,000 in each year thereafter. This is a temporary increase in case processing, which will lengthen the court calendar in 2015, but it doesn't rise to the level of a state appropriation.
What? I'm sorry.
It doesn't rise to the level of a state appropriation. The court is not asking for you to appropriate this money. They're just valuing it, or putting a value on court time. For example, you know, we wouldn't create another 3-judge appeals court panel because of this bill. The BCA, which is on pages 13 and 14, based their estimates on the experience of Hawaii and Oregon. They're here to testify on their own behalf, so I will just briefly summarize it as the BCA is requesting 3 forensic scientists, 2 special investigation agents, a total appropriation of $609,000 from the general fund each year. And, Mr. Chairman, I'll defer to the Department of Public Safety.
I'll ask Mr. Turner, is there anything in the fiscal note that suggests an increase in the illegal use of marijuana that would result in increased law enforcement costs, at least at the state level, in terms of the Department of Corrections or public defender budget or anything like that?
Mr. Chairman, that was estimated, and it can't, as far as the state agency goes, these are fairly low-level crimes. Not many people who are illegally using marijuana are going into our state prison system, and the district court estimate is that there wouldn't be that much of an increase in court activity. And they recorded a minimal impact.
Okay, and that's consistent with the public defenders' results of no fiscal impact. They're not anticipating a caseload increase?
Mr. Chairman, that's correct. They are not.
Thank you. Commissioner Dolan.
Mr. Chair and members, thank you again. And I would like to introduce Wade Setter, the superintendent of the BCA, who will speak to the fiscal note that his division created.
Superintendent.
Mr. Chairman, my name is Wade Setter. I'm the superintendent of the BCA. The Bureau of Criminal Apprehension has two possible roles with respect to the conduct described in this bill. The BCA Laboratory of Forensic Science Services is likely to be asked to test the substances used by individuals who have behaved in ways that are prohibited by Section 3, where there's usage prohibited in certain locations or operating a vehicle under the influence. We have no way to really predict the numbers associated with this, but we can talk about what our current experience is in terms of current examination in the laboratory of marijuana. The other aspect of this is the potential to be requested by local law enforcement to examine suspected falsified or fraudulent documents that are prohibited under Section 17 of the proposed bill. In 6 months, the Forensic Science Service Drug Chemistry Section tested approximately 250 items of evidence to determine if the evidence was cannabis. And again, this is evidence that's submitted to us by local law enforcement partners. This volume is really equivalent to the caseload of about one full-time scientist. And for the purposes of this legislation, we assume that the number of items to be tested will be doubled, simply because there is an opportunity for more marijuana to be present, even though it's legally produced for purposes. One of the concerns we've had in our research is that in some of the states with experience in this, there's diversion of some of the legally produced marijuana for unintended purposes. With regard to the driving while under the influence, we test approximately 100 DWI cases for the presence of THC per year, or per 6 months. It's about 200 cases a year. And once again, we would expect impaired driving requests for blood chemistry for the presence of THC to double, and that's about the equivalent of again, one full-time scientist. Our current capacity of our question document section, which looks at the falsified, fraudulent, or forged documents, could not support any testing of suspected falsified documents needed under the legislation. Under accreditation, if we were to see any increase in falsified documents, we have one qualified document examiner, and we would have to hire a second one for the purposes of peer review of any analysis that's done. With regard to two special agents that are requested under our fiscal note, currently we conduct between 15 and 35 investigations a year with regard to marijuana or cannabis grow and distribution operations. The average amount of one of these investigations is approximately 1,000 hours. In looking at the opportunity or the potential for fraudulent diversion of this of cannabis under this proposed legislation, we believe that adding two agents to our agency to assist not only in those diversion cases, but as well as assisting local law enforcement in training and to understand diversion cases is a very conservative estimate. The formula you have in your in the fiscal note, a laboratory scientist is approximately $125,000 a year with wages and benefits, and the agent is approximately $115,000 a year. That would summarize our testimony. I'd stand for questions, Mr. Chairman.
Thank you, Superintendent. Senator Limmer.
Thank you, Mr. Chair. Superintendent, in your analysis, did you rely on any other or observe any other states in how they handled this policy, and was there a potential of fraudulent use of medical marijuana in those states? Things that we should maybe be cautious about, or maybe send off a little bit of a warning signal to us of what others with less virtuous intent has used to either abuse or take advantage of this new opportunity in other states?
Superintendent.
Mr. Chairman, Senator Limmer, there's two parts to your question. First of all, with regard to the workload and our estimate of that, it's a very I guess, very unscientific estimate, because in contacting our counterparts across the country that have experienced this, one of the things we found is nobody tracks the workload. So it's very difficult to estimate the number of actual FTEs. In the laboratory, it's a little bit easier, simply because that's more of a production environment. With regard to talking to our counterparts across the country who have some experience in this preceding ours, there are two issues. One is with the unintentional diversion of marijuana from the legally produced marijuana environment into the underground environment, so to speak, is one of the challenges. And secondly, the potential for the evaluation evaluation or production of false or counterfeit documentation that would allow someone to legally procure marijuana is a concern and has occurred.
Mr. Chair, do we have anything in this bill that would address the last concern of creating fraudulent or counterfeit documentation in order to justify a medical marijuana use? Is that anywhere in our state law?
Senator Dibble.
I'm sorry, could you repeat the question?
Yeah,
Senator
Mr. Chair, Senator Dibble, the superintendent told us that one of the major concerns in other states that have developed, in those states that have authorized the use of medical marijuana, has been the danger of counterfeit documentation in order to justify medical marijuana use. In your bill, Senator Dibble, have you anticipated the potential illegal, fraudulent counterfeiting of documentation in order to use medical marijuana, and do we have any criminal charges for it, or has that been considered in the cost analysis that we have before us?
Well, Mr. Chair, Senator Limmer, I have a couple of ways of responding. One is, of course, we dealt with the issue of cards being given for purpose to people that are not supposed to have them. We also, we also have, I think, a pretty tight regimen. The unique identifier with the, that is attached to a specific person, and that person can only get their medical cannabis from a specific facility. And of course, that unique identifier has to be verified, be verifiable to both law enforcement as well as the Alternative Treatment Center. That's required regimen that's established by the commissioner through rules. And then also, on page 20, we have the person who intentionally makes a false statement to law enforcement relating to medical use of cannabis is guilty of a misdemeanor. And in addition to any other penalties that apply for making false statements or possession, cultivation, or sale of cannabis not protected under the provisions of this proposal. Submitting false records or documentation is a little bit related to that subject, and that's on line 21.5, subdivision 6. So, no, we don't talk specifically, Mr. Chair, about fraudulent IDs, but I think we establish a strong program of unique identifiers with photographs, that need to be validated and verified. So I think it's a pretty strong program.
Backus?
Mr. Chair and members, too, I just would point out that we do have forgery and the aggravated forgery crimes, which would likely deal with these as well, and probably, depending on what type of forgery it was, I assume it would probably be maybe aggravated forgery. So.
Senator Goodwin.
Thank you, Mr. Chair. And
just questions right now on the fiscal aspect. And
yes.
Okay.
But I want to know, because you're talking about the number of forensic scientists you need, and you have here that in your fiscal note that you said that you test about 200 a year now, and you expect that to double. First of all, I kind of need to understand that, and I need to understand why it would take so long to do 400 tests to see if there's marijuana, if marijuana's been used. So what do you do? What is involved in the test when you test marijuana? I know they can do it in a doctor's office in minutes, or in a hospital in minutes. So I'm wondering why it takes so long to test marijuana. What special tests you do on it that makes it take so long?
Superintendent, Senator.
Mr. Chair, Senator, I have to tell you I'm not a scientist, so exactly how they do it. There is a scientific process that is, we are an accredited laboratory by the American Society of Crime Lab Directors. That analysis is for submission in a criminal proceeding. So it has certain requirements that would not be the same as would be required in a medical facility. So the analysis is using a chemical process, a mass spectrometer, gas chromatograph. They look at it, they analyze it, they then have another scientist review the data to verify it, and then at that point they write the report that is then forwarded to the prosecution.
So this is not just field testing, this is a more sophisticated chemical analysis.
Mr. Chairman, that is correct. This is a confirmatory analysis to say that with proof beyond a reasonable doubt that this substance is marijuana.
And Mr.
Senator Goodwin.
Chair, it's also in this document, it says that 100 driving while under the influence cases is what you have right now. This bill, I noticed, prohibits driving while on medical marijuana, and not that people aren't going to do it anyway, but what makes you think you'd have more when there's already illegal driving under the influence of marijuana? Why would you think, because there's some that are approved for health purposes, a lot of which will be children, why would you have that many more?
Mr. Chair, Senator Goodwin, the reason why we estimate that is just because it's precluded by the law does not mean people will not violate it. And so the marijuana is going to be more readily available in a legal format, but operating while impaired presumably would increase because of availability. Again, our assessments are based on just trying to have a rough estimate of what the impact is of the proposed legislation.
And Mr. Chair, finally,
Senator Goodwin.
That I noticed that you used, and I don't know why you used Hawaii and Oregon in trying to determine what the increases in law enforcement activities would be, because Oregon is legal for all. And I don't know why you didn't use some of the states that have just medical marijuana allowable and have had that done for some 5 to 12 years, and they would certainly know if there was additional costs. So I guess I'm wondering why you chose those two states, not states that have had quite a bit more experience with medical marijuana.
Superintendent.
Mr. Chair, Senator Goodwin, one of the challenges that we found in preparing this fiscal note some months ago when we were asked to do the analysis is it's very difficult to find the type of information that we are estimating here. Our counterparts across the country have done a very poor job of record keeping, to be frank with you. So when we start looking at particulars about workload and impact on our state laboratory, even on our criminal investigative section, that was just our best estimate.
So we should take the fiscal note with a great deal of uncertainty?
Yes.
As best as you can do under the circumstances.
Yeah. This is the best we can do, Mr. Chair.
Thank you. Senator Sharon, did you have a question?
Well, I was going to go along that same line, but I just, for example, in Arizona, we had testimony from Arizona whose medical marijuana law is very close in its tightness and its relationship to this, and they have been able to come and talk about the outcomes to us, which is nice because it's a state that has something in law that's similar to ours. Did you take a look at what they have discovered in relationship to the elements that you're trying to measure financially here?
Superintendent.
Mr. Chair, Senator, I cannot say whether we did. I did not personally prepare the fiscal note, but I can assure you that as of Sunday, I'll be at a conference with my counterparts from Arizona, Oregon, from a number of the states that have the experience, and I will be personally talking in greater detail now that we have an understanding of what the real issues are.
And then just a follow-up question. I know we do these fiscal notes all the time, and it was just dawned on me because when I look at this, I have, in conversations here with Senator Goodwin, indicate that I think these are generous assumptions that create significant fiscal notes. And I just wondered if we have ever asked you, or if you're capable, if this goes through, if it passes, and if the resources are made available for you based on your fiscal note, if in a year we come back and evaluate whether or not your assumptions and the activities that you engaged in were true. I don't know how often we do that, but I know once the expenditure is in the budget, it sort of stays there unless we evaluate whether or not those assumptions were true. So we keep getting requests for financing these bills, and we don't really go back and find out whether or not it actually costs that much to do it, and if we're not just building the budget without really paying attention to whether or not it's necessary. There may be all sorts of resources that we've approved through other budgets for activities based on assumptions that were generous, and that there's money hidden away over there that could be utilized for projects such as this.
Mr. Chair. Senator Dibble.
Senator Sharon, an excellent suggestion, and as you may recall, Senator Rosen had an amendment to the bill. It was a delete all, however we incorporated it, and that's section 21 now of the bill on page 23, in which that activity will be undertaken under the auspices of the Medical Cannabis Advisory Council. An assessment will be done with the first assessment due February 15th of the coming year, but then every 2 years thereafter. And the Advisory Council is asked to work in conjunction with stakeholders, and of course on the Advisory Council is the Commissioner of Public Safety and or her designee. And they're asked to take and work with other larger stakeholders from the community, and looking at the experience of other states as well as the experience of Minnesota over time. And these 8 items on which they're tasked with evaluating include law enforcement activities and concerns, unintended consequences, and the like. So we'll have data to evaluate what our experience is and whether or not some of these analyses that we find in the fiscal note are accurate or sufficient.
Senator Sharon.
That would be great. It just dawns on me that we ought to have an analysis of all of the fiscal notes that we put out, assumptions against what actually happens, because these things just go on the base expenditure for the departments in the formula, and we aren't really going back to see whether or not
needed that.
They actually needed that, and that it was just continuing to fund it at a level without really checking those assumptions a second time. So I'm going to store that away in my head and think about a process for us to do that in the future.
Good idea.
Right, any further discussion, Commissioner?
Mr. Chair, if I could, and Senator Sharon and members, I would just say that based on what the BCA found when they were preparing this fiscal note, that they will be keeping different documentation than what they found when they did the research for the fiscal note, and we would be obviously happy to provide that if we were to be on, if this committee was to be established, but also if you have questions in future legislative sessions.
One last point.
Senator Goodwin.
One last point. On page 23 of this fiscal note, at the very top, it says minimal impact on state and local correctional resources. So I think that's kind of our answer about the impact on state and local resources, at least according to the fiscal note. Thank you.
And Mr. Chair.
Senator Dibble.
I also wanted to be sure to draw members' attention to, where we established the fees in the bill. That's on page 21. That's section 19. It starts on line 26, and it gives the appropriation, et cetera. But it says the total fees collected must generate revenue sufficient to implement and administer the bill. And so, to the extent that the fiscal note is accurate, we'll have to make sure that we're collecting sufficient fees. And those are the $15,000 from the alternative treatment centers, and those are collected on an annual basis. $5,000 from the safety compliance facilities, the $100 per year from the cardholders as well.
So it's your intent, Senator Dibble, that the fees in the bill will render the net fiscal impact zero?
Mr. Chair, to the general fund, yes.
General fund. All right. Any further questions or discussions on the fiscal impact? Thank you, Commissioner. Thank you, Superintendent.
Thank you.
All right, members of the committee, any further discussion? What's your pleasure? Senator Hall.
Thank you, Mr. Chair. I do want to, in this transitional time, tell you a little story that I woke up this morning and got into my car, and what do you think was on the windshield of my car as I started my wiper from yesterday hit was a bag of brownies with no note. To say, true story. Actually, 2 bags. I've been eating on one of the bags. I'll let you know I'm feeling still really good.
That explains a lot.
That does explain a lot, doesn't it? On a more serious note, again, Senator, and thank you, Mr. Chair. Looking at the big picture, and we've been talking behind the scenes on how to best deal with the bigger picture and small details here. The best to me, and I think everybody here, would be that the FDA would approve this and we wouldn't go forward without that approval. That seems likely to some and unlikely to others, but where we're at right now is we don't have that. The second best would be that we would have oil and the pill distributed by drugstores, by pharmaceuticals that are by the state. That's probably not going to happen. So third, and again, I want to say we're careful that we're not breaking the federal laws, and we have to be careful with that. Although we are an independent state, most people, I think, would say let's move forward with this with caution, but let's do something. And I think most people would agree that with our police departments, that the major aspect that I think many of us are concerned about, at least I am, is the plant and the smoking of the plant. So our third alternative for me is that you'd have oil and you'd have pill prescribed by a doctor and distributed by another alternative treatment center. I think the concern, again, is possession of the plant, which we're trying to compromise in this. And so, Senator Dibble, I'd like to present an oral amendment, and I'd like to have Mr. Backus speak to an oral amendment. And may I say, the oral amendment in general takes away all smoking of marijuana, but allows everything else, oil, pill, and the possession, actually, of marijuana, the plant, and distributed by the treatment centers. But it would not have, it would not make legal smoking. Mr. Backus?
Mr. Chair and members, the oral amendment would be on page 4. There'd be two changes there, and then one change on page 17. The main change would be to delete lines 4.22 to 4.25, and then on line 4.26, delete everything before end. That would leave then smoking cannabis as being a prohibited, not authorized by the bill. In addition, we'd need to strike or delete 2 references later in the bill where smoking is specifically addressed, because that would no longer be necessary. So that would be on page 4, delete lines 33 to 35. And then on page 17, delete the last sentence, the sentence on 17.21 to 17.22, the one that begins, "This paragraph does not prevent."
Mr. Chair?
Senator Goodman, discussion.
Yes, thank you. I would like to speak to that because I think I would probably agree with Senator Hall if it wasn't for the people that are on are smoking for cancer treatment, nausea. They can't take the pills. They can't put oil on something and eat it, so that the benefit to that, then they won't be able to benefit from it because, they are on chemotherapy or whatever, and they get very, very ill from that. And the nausea is so bad they can't eat oftentimes. And that's probably true with some other of the diseases that this might cover. So.
Mr. Chair?
Senator Hall.
And I think Senator Dibble can speak to that better, but I believe that the vaporizing of the product would take care of that. But Senator Dibble, would you have a better comment on that?
Senator Dibble.
Thank you, Mr. Chair and members. I believe Ms. Ozzie can help me a little bit. So Senator Goodwin is correct that taking cannabis in just oral or topical forms, whether that's oil or pills or whatever, works well for some people, does not work well for others. It's completely ineffective for some, and also there's that issue that Mr. Stubbs talked about there are two major issues. One is a time factor, the immediacy of efficacy that also relates to, which he didn't talk about, but we've had testimony previously at Senator Sharon's committee, which was people are able to what is termed self-titrate. They can control much more precisely the amount of dosing that they need of a particular type of cannabis in smokable or vaporized form, so that just one inhalation, two or whatever, the immediate effect, and then they can stop if their symptoms subside, because they can be quite severe and quite immediate. I don't know a lot about the distinction between vaporizing and smoking. I'm given to understand that vaporizing accomplishes a lot of the same effects as smoking. Maybe Ms. Ozzie can help me. The issue that begs, though, of course, is that folks need to acquire a vaporization unit. It's quite expensive. It can be a couple $100 to $500. It's also difficult for some to handle if they're not receiving assistance. So I'm open to the discussion around vaporizing. Now, that would, of course, entail the full plant, the plant material. There are substances in the plant material itself that that might need to be there. There's this what they call entourage effect. The compounds interact with each other in ways that we don't completely understand, and that's necessary for some people in some conditions. But Ms. Ozzie might have a little more information.
Ms. Ozzie.
Mr. Chair, members, I think Senator Dibble covered it fairly well here. There is a medical need for the inhalation to be available, and technology is improving pretty quickly now to the point where we do have devices that are able to heat the plant and to produce a vapor that can be inhaled without actually combusting it and smoking. If we were to remove smoking from the terms of this bill, the result, of course, would be that it would be punished by existing law, which does include a referral potentially to drug treatment and a criminal record. So my concern would be related to those items, and I would encourage the members to maybe consider inserting a new penalty for that conduct rather than relying on existing law.
Could you explain that again, please? I didn't follow you.
Sure. Under Minnesota's current decriminalization law, a person who possesses a small amount of marijuana or who smokes marijuana, for example, would be subject to a civil penalty. They would be potentially referred to drug treatment, and they would receive a criminal record. A patient who would be using their medicine incorrectly under the terms of this law would then be potentially banned from using their medicine.
If the amendment. We do. Let's vote. Just the general law.
If you did this, they would make.
Regulation here.
I'm sorry, maybe if we
Mr. Backus.
Yeah, can we just have more clarification on that? Are you talking about the possession of a small amount of marijuana under 152.027 or something else?
I don't have the code in front of me. Sorry.
Senator Letts, could you help me understand why we're talking about this?
Yeah, I think, let's do this. If the amendment goes on, then maybe we can have some analysis done as if there any ancillary changes need to be made, and we can take a look perhaps at doing those at a different stage of the process, because I don't think we're going to sort that piece of it out here today. We'll need a little time, I think, to sort through some of that. in order to address your concern, which I'm not quite sure exactly that I'm following it either. So might be some more discussion needed to address that. But the bigger question now is Senator Hall's amendment. So is there any additional discussion? Is there anyone that you'd like to have testify in connection with this particular question, because it's a significant potential change to the bill?
Well, Mr. Chair, I think Mr. Stubbs had to leave for the day, but I would just refer you back to his testimony. I would be opposed to this amendment, just to be clear, if I wasn't before. And the reason is I would be concerned that I don't think it allows for the vaporization. I don't think we've had enough conversation about that. I'm open to that conversation going forward. But just as I understood Senator Hall's intent, it was to confine to, more oral and or topical, and no ability to use the full plant.
Well, let me ask Mr. Backus, is it your understanding that this change would or would not allow vaporization?
Mr. Chair, members, I'm not sure I can really answer that. It would leave the prohibition, expand the prohibition in the bill on page 4 to prevent smoking cannabis. So that would not be authorized under the bill. It doesn't mention vaporizing. I think, the way it's drafted, that would have to be interpreted by a court.
Mr. Chair.
Or we could put language in theoretically that says this does not prohibit vaporization.
Mm-hmm.
Senator Hall?
And that's my intent. Yeah, my intent is every alternative that we've been talking about would be there, but the alternative, except for the alternative of smoking, combustible. So this would be heating in a vaporizing. That's different to me. Or putting it in brownies, if that's their choice. And that's prescribed by the doctor for some reason, then I would accept that.
Let's just vote.
So, Senator Dibble, if there were language in there clarifying that, as Senator Hall is saying, is his intent that it would not prohibit vaporization? Well, or other whole plant use, perhaps?
Other whole plant use.
Or other whole plant use.
Oh, you may use other whole plant use.
Yeah, so no smoking, but it would not prohibit vaporizing or other whole plant use.
So, well, Mr. Chair, like I said, I continue to have concerns. I think I'm interested in that conversation.
Well, we're having it right now.
Right.
So.
Right. But the proposal, as was presented to me earlier, was a dramatically different proposal. Like I said, I have concerns with just going with vaporization because, like I said, these units are extremely expensive. It will present a barrier to a lot of folks. I'm not completely opposed, but I'm kind of opposed, if that gives the committee any guidance.
Well, one thing we haven't. Nope. One thing we haven't inquired about, and maybe this is a subject of a different committee, but what about medical insurance coverage? Do we have any idea? For example, would a vaporizing machine be a medical product that would be covered by health insurance if it were prescribed? Or how does that fit in? And maybe this is opening up a whole other can of worms, but you're talking about costly, prohibitive delivery system.
Right. Well, Mr. Chair, my guess is that would not be a reimbursable or a covered expense. If you look at, we specifically say ourselves, line 4.30. Nothing requires medical assistance, Minnesota care programs. Ms. Ozzie whispered in my ear that there's a federal prohibition from allowing that. As well, we go back and we add, I mean, I suppose we could take out, but we say in Section 22 for the drug formulary that the formulary shall not include cannabis. And I think those are all efforts to stay in conformance and compliance with industry practice and federal law. So,
okay, so no insurance option.
Right.
All right. Any other discussion? Senator
No, we were just talking, Mr. Chair, about how long this hearing has been, so I think, let's wrap it up.
Let's vote.
I was just
got a conference committee supposed to start 5 minutes ago.
Yeah,
so
I was just going to say, I have the concern that the brownies, I think, would be more, and maybe you missed this, I was in tax committee, sorry, but the brownies would be more open to others, like children, seeing them and not realizing that they can't eat them and then just grabbing them. So I would have more of a concern with that. So.
And Mr. Chair,
Senator Dibble,
can I just say this? The push, you know, I'm interested in the conversation around vaporization, sure, but the whole premise and the pretext of it, you know, we've done a lot to address concerns around smoking, where folks can smoke and under what circumstances, in front of whom, and et cetera, et cetera. A lot of the concerns around smoking are driven by issues that are articulated that just aren't borne out by the evidence. Increased teenage use, it doesn't happen. You know, driving concerns. You know, we handed out studies. It doesn't happen. Diversion, those sorts of things. You know, sending signals. I mean, it in my view, it reinforces some thoughts and ideas that just aren't borne out by the evidence, and we know of its efficacy, and it creates, you know, an access issue and an ease of use issue that some people need. We can go to the vaporization, but we have a pretty significant choice to make if we do that. We're kind of reinforcing some objections that just don't stand up to the scrutiny of the evidence, and we're creating, and we've done a lot to address concerns that are well-founded in the bill, and like I said, you know, these vaporizers may be great, but you know, I'm sure the vaporizing manufacturers would love for that to be the only option for heated use of the full plant material, but that's why I'm having a struggle with this idea.
all right, any further discussion on Senator Hall's amendment? Senator Hall, did you wish to add any provisions to your amendment along the lines of vaporization or not? Since we had the discussion, I want to make clear that we know what we're voting on.
Well, I think Senator Disick brought a good point on the brownie issue and that, but again, if there's a prescribed best for people that come from the doctor, and their brownies are the best way of doing it, you know, and they have to do it within certain parameters, I guess I can understand that. But let's leave it at this point the way it is and vote on it the way it is if we could.
Okay. Senator Sharon.
Well, I really am ready to vote as well, but I just would remind the committee that the FDA ruling on vaping is that it's going to be defined as smoking at the federal level anyway, so it'll all fall under the same definition, no matter what we do at the state level.
All right. To Senator Hall's motion, all those in favor say aye.
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 Opposed?
No.
The motion does not prevail. Amendment is not adopted. Any further discussion or further amendments? Senator Newman.
Thank you, Mr. Chairman. If we could have the A14 amendment passed out. And while it's being passed out, members, if you want to turn to page 2, subdivision 7, and on line 2.2, that's what the amendment addresses.
H2 line 2.2.
Two, I think. I believe. Now this is page 6. 6, line 14.
Later.
They would be eating at my house. They're good.
No subdivision.
Not bad. Right, this doesn't fit in here.
Seven.
Yeah.
Mr. Backus?
Mr. Chair, members, I just realized I believe the amendment needs a technical amendment on line 1.6. If you delete 5, as in subdivision 5, and insert 7, that's the definition of debilitating medical condition being referred to.
Senator Newman, you incorporate?
I do, Mr. Chairman.
Senator Newman, would you like to speak to your amendment?
Thank you, Mr. Chairman. Prior to the hearing today, I had given Senator Dibble a copy of the amendment just to give him an opportunity to take a look at it. But we were kind of rushed, so I didn't have a chance to really speak to him about it. But essentially what we are doing in subdivision 7 is legislatively we are laying out the various debilitating medical conditions that medical marijuana can be used for. And we're doing it through the legislative process and through the normal hearings, committee hearings, et cetera. There is, however, at paragraph 4 in line 2.23, in effect, an omnibus clause that gives the Commissioner of Health, the authority to add future debilitating conditions, and I don't see any limit on that. This is a pretty controversial bill. It's a pretty controversial subject, and I don't think that we as legislators should let go of what is or should not be included as a debilitating medical condition. But I recognize the fact that the Commissioner of Health may have very good reason to add something while, for instance, we are not in session. So all I'm trying to do here is give the Commissioner of Health the ability to add a condition should it be appropriate in the mind of the Commissioner. But then it comes back to us, and then we will decide whether or not, we as a legislature will decide whether or not it's a good idea or not. So I'm trying to hold that within the legislative body. And that is the purpose of the amendment, Senator Dibble.
Senator Dibble.
Mr. Chair and members, and I appreciate Senator Newman showing this to me ahead of time. I should have mentioned that Senator Hall also spoke with me, and we had some conversation ahead of time too, and I'm grateful for that. And also, while I'm thinking of it, I'd like to continue this conversation, Senator Hall. So we're not done.
Thank you.
All right. Mr. Chair and members, my only thought is this. We have the list of debilitating conditions in this proposal to create some limitation from the outset. Again, an effort to keep in the overall spirit and effort of the bill, to send a very strong signal that this is a very conservative approach, very limited, very strict regimen that we're establishing, so that we're not like the bad state that did it so horribly from the outset, but we're like the good states that are doing it really well. So I really like paragraph A, that there's lots of notice and advice. I'm not sure it's necessary to require the legislature to continue to proactively place the items on the list, because I do think we have a pretty good process in place for the commissioner, because I don't think we're going to get a commissioner who goes off half-cocked and starts throwing crazy things onto the list, and the commissioner is required to do public hearings, et cetera, et cetera. I do think, though, paragraph B, we have this, maybe we could do an opt-out version on paragraph B rather than an opt-in, if you will. I think we're talking a lot about opt-in versus opt-out this legislative session on various subjects. So I would be interested in Senator Newman's response to that idea. Rather than requiring an affirmative ratification by the legislature would have to affirmatively delist an item that had been added by the commissioner. Otherwise, it would remain on the list.
Senator Newman?
Mr. Chair, Senator Dibble, so long as the legislature has some type of affirmative notice so that we know that something has been added, would then give us the ability to react. Then, if that would be agreeable, then Senator Dibble, yes, I would agree with an opt-out.
Mr. Backus?
And Mr. Chair,
Senator Dibble?
Maybe even going one step further, maybe the legislature would have that opportunity to act before an item actually landed on the list. So the legislature would have to affirmatively delist. So an item would be placed tentatively on the list. Legislature would then convene, and if they adjourned without delisting, then it would go on the list and be available to those who suffer from that condition.
Right, well, let's do it.
Does that make sense?
Now, Mr. Chairman, we'll see how fast Mr. Backus can react.
Well, you keep paragraph A. Keep A. Yeah,
Keep A.
Mr. Chair, can't we just divide the amendment?
That's a good one.
I'm sorry.
Well, one option would be just to delete paragraph B, because the legislature always has the opportunity to affirmatively take steps such as delisting something. And I suppose the other option would be to say that the commissioner's addition of any condition is not effective until after the legislature has adjourned the session immediately following, the proposal to list an item.
Yes.
Yeah, and Mr. Chairman, if I may, although it may be somewhat redundant, I would like to see some type of language in paragraph A then that would say unless otherwise decided by the legislature. In other words, tip off legislators to look at the issue rather than just leaving it blank. And I think it would be somewhat redundant because you're right, we always have ability, but I would like to see some kind of a trigger or something to bring this to our attention to remove something. I don't know how to phrase that.
Mr. Chair, that would be agreeable to me.
13, 14. Mr. Backus a moment. See if there's any further discussion. Senator Dibble.
Mr. Chair, did we want to get back to that conversation about law enforcement's authority to investigate and search premises? And all right, all right, all right.
5 hours.
So let's clarify for Mr. Backus exactly what the intent of Senator Dibble and Senator Newman is. You want a preliminary listing not to take effect until after the legislature has adjourned the session, or did you just want to delete paragraph B altogether and add an affirmative statement that the legislature may take affirmative action to delist?
Mr. Chair, either route, I'll defer to Senator Newman's preference.
Mr. Chairman, it would seem to me that the second preference, or the second idea, would be simpler and cleaner. Just delete paragraph B and then add a paragraph A that the added medical condition would remain unless we delist it, or however you phrased it. And in reality, I think all that is just bringing it to our attention. That's all. That's all we're doing. And that would be fine with me.
The legislature, in its supreme wisdom, shall. I'm sorry, Mr. Backus.
Mr. Chair and members, and if we delete on line 1.5 the parent A, and then 1.11 after the period in council, insert the added disease or condition remains in effect unless the legislature by law provides otherwise.
Yeah, that sounds good. Go with it.
Brilliant. Senator Newman agrees?
I agree.
All right. It's incorporated into the amendment. Senator Dibble, okay?
Sounds great, Mr. Chair.
Any further discussion?
No.
All those in favor of the amendment as amended, the A14 amendment, say aye.
Aye.
Opposed? Motion prevails. The amendment's adopted.
Okay.
We were going to return to two other topics I promised we'd get back to. One Senator Dibble just mentioned, having to do with the probable cause for the cards. Or did we address that? We did not address that. Okay.
Mr. Chair, I think we did.
We had addressed the probable cause for the cards. The part we had not addressed was the language on the alternative treatment center search and prosecution question. That was on page 16. And Mr. Backus has some proposal to address those concerns that were raised by the committee.
Mr. Chair and members, the proposal would be to make the same changes to both subdivisions 8 and 9 on page 16. And the changes would be as follows. On line 16.10, before N, insert parent A. On 16.14, delete the comma and insert a semicolon. And then after line 16.29, insert a new paragraph B that would read, the immunity provided in paragraph A does not apply to activities that are not permitted under sections 152.22 to 152.38 and rules authorized by sections 152.22 to 152.38. And then to make those same exact changes to subdivision 9. So again, to reiterate, the new paragraph B would read, the immunity provided in paragraph A does not apply to activities that are not permitted under sections 152.22 to 152.38 and rules authorized by sections 152.22 to 152.38.
So if your conduct is outside the scope of that authorized in those specified sections, then you don't get the immunity from prosecution, search, or inspection.
Mr. Chair.
Sounds good.
Senator Dibble?
That is in keeping with the intent. So that's a good amendment. I support it.
All right. Senator Goodwin offers that amendment. Any questions or discussion? All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment's adopted. Mr. Backus, we're going to return then to the affirmative defenses on page 18.
I'm getting silly.
This is a proposed amendment. We'll need a committee member to offer.
Mr. Chair and members, this would be, again, changes to the affirmative defense language, section 15 on page 18. Let me maybe explain the concept. It might make things a little bit easier. It is an oral amendment. It would be to limit the affirmative defense so that it would apply only to the possession of cannabis. It would apply the affirmative defense only to the person who has the actual medical condition, so it wouldn't be the caregiver, and it would require that the person have to have the statement by the medical professional at the time of the offense. So it wouldn't be something that could be testified to after the fact if the person didn't have that statement earlier. So the changes then would be on line 18.17, after involving, insert the possession of. And then on 18.19, after the parent A, insert, at the time of the offense, the person had obtained a written statement from. And then after practitioner, delete has stated, and insert dated within the preceding 90 days stating, and I'll read this to you in a second. And then on line 18.20, delete current. 18.21, delete patient has, and insert person had. And then the remaining changes would be essentially to take words like individual, defendant, or patient and convert them to person or persons as appropriate. So that would be on line 18.27, 18.28, 18.30, 18.32, 18.33, and 19.3. So again, the main change would be, again, in paragraph A, the defense would be for any, on line 18.17, for any prosecution involving the possession of cannabis. And then on 18.19, that sentence would now read, parent 1, at the time of the offense, the person had obtained a written statement from a practitioner dated within the preceding 90 days and stating that, in the practitioner's professional opinion, etc.
Mr. Chair, the effect is?
Mr. Chair and members, the effect would be to limit the affirmative defense so it only would apply to the actual patient, the person with the condition that necessitates the use of the marijuana, and it would only apply to a defense for possession of the marijuana, essentially. So it wouldn't apply to the person selling it or anything like that, just the person possessing it and using it.
And then finally, that at the time of the offense, they had to have already gotten the written statement from the physician that they needed it for a medical condition. They couldn't go back after the fact and say, oh, now I'm going to go to my doctor since I've been caught.
Oh, great. Gotcha. Okay, great.
So,
I'll make
Senator
the motion.
Goodwin makes that motion. Senator Dibble?
Thank you, Mr. Chair, members. I think these are good changes. They tighten up, make less imperfect and imperfect circumstance, which we've talked about in detail. It does create a little bit of a dilemma, though, for parents who need to possess the substance on behalf of their children. I don't know if we can solve that today here, the time allowed, or not. But I would just raise that concern.
Just insert or parent of a child.
Well, Mr. Chair, it might, I didn't think of that, but it might also affect those that are in medical conditions where they need a caretaker or somebody to possess it for them. I don't know. Is that correct, Mr. Backus?
So basically, Senator Goodwin, you're asking about reinstating the caregiver.
Right.
Are you interested in state tonight?
Nobody but
although we we wouldn't have as formalized yet a caregiver relationship as is established in the bill, I don't think, would we? Not by this point in the process.
Okay, well then
Or,
it's okay.
or we could say, or a caregiver as defined in the bill. So if they fit within the parameters of caregiver in the bill.
Makes sense. Yeah, I'll move that amendment.
Senator Dibble, is your definition of designated caregiver intended to cover parents who are taking care of their children? Or are they covered somewhere else in the?
Mr. Chair, in the let me find out. We do have a special section where we talk about minors and their access. I think what occurs in that case is that parents do become their designated caregivers. Do you know where that is? Yeah, I think it's in the section where we allow for the designation of the cards. So page 8, line 30. So this is the issuance of the registry identification cards to minors, providing for some standards for the practitioner, making sure there's been at least 2 practitioners, parent or guardian, or whoever has legal custody has to provide permission, and then consents in writing to serve. So in that instance, they serve as the qualifying patient's designated caregiver. They control the acquisition, et cetera. So maybe, Mr. Chair, we can make a reference to those individuals under 152.26. Parent, guardian, or person having legal custody being the designated caregiver.
That works. Works. It works. So happy that.
Okay. All right, members, I think what I'm going to suggest we do is we can agree on the concept and then let Mr. Backus work out some specific language which we may need to tweak down the road. But otherwise, we're going to sit here for 10 or 15 minutes while we kind of work out exactly how this should be written. So, fair enough. We don't usually like to do that, but I think under these circumstances,
yeah.
I see a lot of heads nodding. So, Mr. Backus, we're going to lay it on you. These are just parents.
Do you?
I would just say parents.
That's not.
Not being official caregivers. Well, no, there will be after July. Not formally registered.
And they really are in the city.
So the question, members, I think it's easy to state parent or guardian, but the tougher thing is to explain or to write it in such a way that's got appropriate limitations for if you have an adult person who is sick that needs a caregiver who would possess and would legitimately be entitled to an affirmative defense for that purpose.
Correct.
So let me ask the question to members. The members desire to include that category of caregivers in the affirmative defense category to possession prosecution as well?
Yes.
Okay. Then I think we'll just give a conceptual direction to Mr. Backus if the amendment passes, and let him work on some language. Just incorporate that language in the bill.
He's good at that.
All right. So, Senator Goodwin.
Thank you, Mr. Chair. I would
Makes that
move the bill.
Well, no. You have to
1641. We have to move this amendment first. Oh, I will
give the direction.
I will move the amendment that Mr. Backus cleans up for us.
Okay. All right. Any further discussion, questions about that amendment?
I'm EDD.
All in favor say aye.
Aye.
Opposed? Motion prevails. The amendment's adopted.
Now, Mr.
Now, is there
Chair.
any further discussion on the bill itself? I think we've covered everything we said we'd go back to look at.
It's a great bill right now, Mr. Chair.
Senator Newman.
One question on the motion that is about to occur, Mr. Chairman, and number one, where is it going to go from here?
Finance Committee.
Thank you. And my second question is this, is that this is a bill, it seems to me, that is really worthy of further discussion and looking at, and involving as many of us legislators as possible. So my question revolves around the issue of moving it out of the committee with a recommendation that it pass versus moving out of the committee without recommendation. And I'd just like to know what Senator Dibble's thoughts on that are. And I bring the subject up only because I'm not sure that I am comfortable with voting to pass the bill. I certainly think that it is worthy of getting it to finance and having more discussion, because it seems like every time this bill moves, it changes, is tightened up, and is improved. So those are my thoughts, Mr. Chairman.
It becomes better, especially after the Judiciary Committee's looked at it.
More than, yes. But your thoughts, Senator?
Well,
Senator Dibble.
Mr. Chair, I think the work of the Judiciary Committee has been brilliant, and I think it's a darn good bill. My preference would be that it be recommended to pass and sent to full finance. But I would just like it to get to finance as my higher ordered priority. I don't know that it does it damage without recommendation, but of course my preference would be that it be recommended to pass.
Mr. Chair.
Senator Goodwin.
I would agree with that, because I remember one bill this year, and I can't tell you which one it was, that we put it through without a recommendation, and that was argued against, that was used against the bill when it got to finance. So I would prefer to pass this out, and I would make that motion. Senate File 1641 be passed and sent to finance. As amended and sent to finance. Thank you,
Senator
Limmer.
Yeah, thank you, Mr. Chairman. And just so there isn't any misunderstanding, it would be my intention to vote for the bill to pass it out of committee. I don't think it should get stuck here. But if it's a vote with a recommendation to pass, I'm not comfortable with the bill in its form to do that. So that's, in effect, my offer to Senator Dibble is to vote to pass the bill out without recommendation. But if it's with a recommendation to pass, then I'm afraid I would have to decline.
Mr. Chair.
Senator Dibble.
Sounds like a great offer to me, if I don't lose any other votes.
All right. So it's the chief author's preference that the bill be passed without recommendation or be referred to finance. Is that correct, Senator Dibble?
Yes, Mr. Chair. I think this bill benefits from bipartisan support a lot. So even if it's not a recommendation to pass, it still gets where it needs to go. And I think it's a strong bill, and I think it's actually gaining a lot of support, a lot of momentum from people with a lot of different perspectives.
And if I may, Mr. Chairman, to Senator Goodwin's concern, I can't speak for anybody else, but I will tell you that I will not speak against the bill on the basis that it came out of this committee without a recommendation. That's the best. I can't speak for anybody else, but I can't speak for me.
Mr. Chair.
Senator Goodwin.
Senator Newman, if you just talk to your caucus about that, then that would be
Only talking about me.
Senator Goodwin, do you wish to amend your motion in accordance with Senator Dibble's
Actually, no,
preference?
but I'll drop my motion and let Senator Newman make the motion.
All right. Senator Newman.
So moved.
Okay, Senator Newman moves that Senate File 1641 as amended be passed without recommendation and be re-referred to the Senate Finance Committee.
No.
Is there any further discussion?
Would you? I'm confused about what the motion is right now. Are we recommending it to pass?
We're passing it without recommendation. Motion is to pass without recommendation and re-refer it to the Senate Finance Committee.
Oh, yeah. Better than not passing it at all.
All right. Everyone understand the motion?
Yes, we do.
All those in favor say aye.
Aye.
Opposed?
No.
The motion prevails.
Thank you, Mr. Chair.
Thank you, members. The committee is adjourned.